Yeah, it's on. And off. It's on. Mm. Hello, ladies and gentlemen. Welcome back to day 2 of our Insolvency Law and Business Rescue Symposium. We are live at the Golden Tulip Hotel, and we are thrilled to have you back here for day 2 of this event. The theme of our symposium this year is Stakeholders as Catalysts, Driving Business Rescue and Continuity. So once again, my name is Angomro Julie. I'm the Program Officer for Professional Development at the Uganda Law Society, and I'm going to be your moderator for today. So I'm going to first start with an opening prayer before we delve into the details of the day. Let's humble ourselves for a word of prayer. Heavenly Father, we thank you for this day. We commit this symposium into your hands. We commit our speakers into your hands. We pray, Lord, that you give them wisdom, enlightenment, and understanding. And we pray for our attendees, Lord, that they will comprehend and participate, and that this information will help them in their day-to-day work. We thank you, Lord, for you are good. We pray all this believing and trusting in your holy name. Through Christ our Lord Jesus we've prayed. Amen. Yes, thank you so much. And I'm going to give a recap of day 1. Yesterday we had a wonderful time with our different presenters. We had an exceptional lineup of presenters from the various stakeholders in insolvency and business rescue. We had URA represented by Miss Diana Prida Prof, and she led us through the role of URA in business rescue, where we got to learn and understand the different engagements and how URA has been very instrumental, and their attitude towards business continuity and business rescue. Most of us associate the taxman with heavy burdens, tax burdens, and some people have this perception that the taxman doesn't even want businesses to prosper, but we got to understand that this is not the case. And we also had a presentation by Mr. Andrew Munanura Kamtera from S&L Advocates, who tackled the roles of a lawyer in ensuring business survival. And he delved into some of the different, he gave us recommendations on how a lawyer should advise their client. And we looked at how litigation is not always the best resort when it comes to a business that is in distress. We have to look at many other alternatives. We have to look at things like debt renegotiation, restructuring the organization, because you'll find that sometimes a company may be in distress because of a wrong person that you've hired, who could be siphoning, the funds, the capital away from the company. So looking at who are the right people to hire. We also looked at what are some of the things that they should do. You can advise your client to approach, you can advise your client to approach the entities, the banks that have lent you money, as opposed to waiting for it to become too late. Yeah, the earlier the better, to ensure that your business can survive, your client's business can survive. Then we looked at various things like how we should have a restructuring plan, to agree on the different prioritizing the repayment plans and all those other different things, like cutting non-essential travel and everything that you can do to ensure that your client's business survives. Yes. Then we also had a discussion on the role of banks in business rescue, and this was by Mr. Andrew Mauso. Mr. Andrew Mauso heads the Legal and Recovery Department at Stanbic Bank, and we looked at how can the banks come in to ensure business rescue. And we had an in-depth discussion on what amounts to business rescue and what is the attitude of banks when it comes to business rescue. Do they genuinely want to engage with an entity that is undergoing business rescue? And we also looked at what are the forms of forms of engagement that can aid business rescue, and what advice should we as lawyers give entities that are going through business rescue or close to distress. Then we looked at recommendations to the industrial players and practitioners in this regard. And then finally we had a panel discussion on the role of government in insolvency, where we had an exceptional lineup of various stakeholders. We had Mr. Luke Kasacha from NSSF, and we had Mr. Hamidu Tumuhimbise from URSB, and we had Mr. Tony Kalonji from URA, who gave us an overview of what are some of the roles that they play to ensure business continuity and survival. And it was an in-depth discussion. It was insightful, and we are thrilled to have another exceptional lineup of speakers for today. And today we are going to delve into unpacking the Emerald Hotel case. I believe many of us have been following this case. This case has been in court for over 20 years, And today we're going to know why. We're going to understand the principles that are in this case. It's Emerald Hotel and 3 others versus Barclays Bank. And thereafter, we shall have a panel discussion discussing basic principles in this case and just principles of what was already decided. Yes. And then in the afternoon, we shall have a discussion on insolvency in the digital economy, dealing with emerging business models in Uganda. Yes, and thereafter we'll have the insolvency in the digital economy will be handled by Mr. Paul Kasami. And insolvency, in the afternoon, we're going to have insolvency and tax planning. Where is the line between strategy and abuse? And on this panel, we're going to have Mr. Nelson Nerima. We're going to have Ms. Rachel Niringie from URSB. We're going to have Mr. Isaac Salimugera from Bluebell Legal Advocates. And we're going to have Mr. Tony Kalonji once again from URA. So right now, I'd like to usher us into first presentation of the day, and that is unpacking the Emerald Hotel Limited versus Barclays Bank case. And we're going to have Mr. Solomon Byuruganda from Otas Advocates to take us through this session. Thank you so much. Over to you, Solomon.
Thank you. I'm Byuruganda Saddam Solomon from Otas Advocates, and I have the privilege of presenting to you our today's topic, which is unpacking Barclays Bank Uganda Limited and 2 others versus Emerald Hotel Limited and 3 others, and Shumuk Properties Limited and another versus Emerald Hotel Limited and others. These were civil appeals number 70 and 72 of 2017, which were consolidated. Today we shall not delve a lot into the facts of the case or a lot of aspects which were and other determinations of the case. We shall only delve into receivership, which is in line with our symposium and in line with the corporate rescue. But the main aspects which were decided on or determined this matter included corporate finance, securitization, which includes mortgages and debentures, loan default, then corporate management and unveiling of corporate veil, receivership, and management under receivership. But the brief facts, just briefly, these were consolidated appeals challenging the decision of the High Court. The appeal had been filed by Barclays Bank against Emerald Hotel, and Emerald Hotel had also filed a counter appeal, and there was also a different appeal by Shumuk Properties, also challenging the same decision. These were loans which had been advanced by Barclays Bank to Emerald and secured by mortgages, debentures, a third-party property, and had gone unpaid for some time. I hope you're following. I just realized the PowerPoint was not shifting. I'll try to give brief details of the case for the benefit of the attendees who may not have been following the case. But basically, this was a case revolving around loans and securities and receivership. And in this case, Emerald Hotel Limited had obtained loans for construction of phase 1 of the hotel from Barclays Bank. One of the loans, the first loan, included also buying off a loan which had been obtained from FCU Bank, and a number of documents, security documents, had been executed, including mortgages, which were executed by third parties because the property was not in the names of the hotel, and also debentures over the properties of Emerald Hotel. The loan, there was a grace period within which the loan was to be paid, and also the security documents clearly provided for appointment of a receiver in circumstances of default. The loan went bad, there were no payment, which triggered the bank appointing a receiver. When the receiver was appointed, a receiver executed the management agreement with Shumuk Properties. However, the appointment and the execution of the management agreement was challenged by Emerald and the stakeholders in Emerald Hotel. And following this challenge, also the bank put in a counterclaim for breach of the loan by default, and also for deception and fraud on behalf of Emerald Hotel. The High Court decision is a bit lengthy and tackled a lot of aspects, but briefly, at the High Court level, court found that the appointment of the receiver was okay and was done in accordance with the law, and the documents executed. Court also found that the security documents had been validly executed. Court found that there was default on behalf of on the side of Emerald. However, despite finding as follows, court issued decisions. In the main suit, it ordered the receiver to vacate the properties, and also awarded substantial sums in special damages and general damages to Emerald Hotel. And in the counterclaim, court also granted special damages to Barclays Bank. And all parties who were involved in this matter were dissatisfied, and this led to the appeals and the counter appeals. And briefly, the Court of Appeal upheld the loan documents and found that Emerald Hotel had defaulted on the loan and was in breach of its obligations. Court also went ahead to lift the corporate veil. That was for Crystal Ways, which was an associate company which had been incorporated way before Emerald Hotel was incorporated. Court upheld the receivership and the management agreement and found that the receiver had been properly appointed, and also found that the management agreement which had been executed by the receiver with Shumu was properly done and in accordance with the powers of the receiver. And court set aside the damages that had been awarded to Emerald Hotel, and also ordered the receiver to audit and sell the hotel within 6 months. And court went ahead to dismiss the appeal that was filed by Shumu. Now we are going to delve into some of the main aspects that came out of this decision in line with our theme of this symposium. Court, in highlighting the purpose of the appellant court, tackled the aspect of credit vis-a-vis insolvency, and court emphasized the importance of credit. Court relied on the book of Professor Roy Goode, Principles of Corporate Insolvency, to note that there cannot be any world without credit, and you can't imagine any businesses operating without credit. And also noted that credit facilitates the smooth running and expansion of businesses. And of course, like we have discussed just briefly in the facts, what the judge was pointing out is clear, because it is clear that these facilities had been advanced basically to expand the business, and therefore showing the importance of credit within the running and expansion of business. Court also defined insolvency as the inability to pay one's debt. And court noted that insolvency originates from extension of credit, because since insolvency is the inability to pay, then for you to be in a situation of not paying the debt, there must have been a scenario where credit was advanced to you. And this also falls within the theme of our symposium on corporate rescue, and how credit is so important and embedded within insolvency and the different modes of credit rescue. On the issue of appointment of receiver, court emphasized and reaffirmed the rights of a debenture holder to appoint a receiver in accordance with the debenture. And this, I'm sure that the banking world welcome this, because it reaffirms the powers and the duty of court to enforce the terms agreed upon in the debenture, and also the powers of a debenture holder in case of default, which include, among others, appointing a receiver. Court also recognized court's powers to appoint a receiver, and court noted that a debenture holder's power to appoint a receiver is regulated by the express and the implied terms of the debenture. Court, in arriving at this, relied on the David Bachivinga's book, Company Law in Uganda, 2nd edition, 2013. So from the holding of court in line with the powers of the debenture holder in appointing a receiver, it strikes and calls us upon to reflect on the terms of the debenture, because court clearly says that the powers to appoint a receiver is expressly governed by the express terms or implied terms of the debenture. So this means that if you are drafting a debenture, and this is one of the powers that the entity advancing a facility wants to get, then you must expressly point out the circumstances under which a receiver will be appointed, and all aspects that resolve around the appointment of receiver. Is it by default? Is there any event that will trigger this appointment? What will be the procedure for appointment of the receiver? So this shows the importance of paying attention to the terms of the debenture. Court also went into powers of a receiver, because one of the things that was challenged was the execution of the management agreement with Shumuk. So court had to look at what are the powers of a receiver once a receiver is appointed. So court held that the powers of a receiver are governed by the debenture instrument, still emphasizing the need to have comprehensive and clear terms regarding appointment and powers of a receiver in a debenture instrument. Court noted that the powers of a receiver are quite extensive and are aimed at repaying the mortgager's debt. And this highlights the cardinal role of the receiver once appointed, which is ensuring the repayment of the debt. Court went ahead to reproduce the terms that had been agreed upon on the powers of a receiver in the debenture, and the debenture clearly provided that the powers included taking possession of, getting in, carrying on or co-carrying, in carrying on, selling, leasing, and dealing with the property and assets of the company. So as noted, one of the question was, or one of the things that were challenged was the execution of a management agreement and the taking over of the property. So given the fact that court had noted that the powers of the receiver are governed by the express terms of the debenture, the express terms of the debenture the debentures in question clearly provided for the right of taking possession of the property and dealing with the property. And therefore, in this line, court found that the taking of possession by the receiver was in accordance with the terms agreed upon, and even the execution of the management agreement was also in accordance with the powers that had been agreed upon. Then on duties of a receiver, court found that a receiver owes a duty of care to the debenture holder, and this, according to court, is the primary duty. The debenture holder is the one who appoints a receiver, and therefore the ultimate duty, according to court, is owed to the debenture holder and not to the company. Court noted that a receiver has a limited duty of care to the company, and therefore if anything is complained of against the actions of the receiver, it should be by the debenture holder. One of the issues that and the relief that had been granted at High Court was an amount of 14 million, which had been transferred to the receiver, and the High Court had ordered for it to be refunded in terms as specific damages. However, court, in setting aside this remedy, noted that the receiver owed the duty to the debenture holder and not to the company, and the duty to the debenture holder was to ensure that the receiver takes over the property, runs it, to ensure that the outstanding sum or outstanding loan is recovered. And court set aside that remedy which had been granted at High Court on ground that Barclays Bank had not complained about that money against the receiver. So that showed the balancing of the duty between the debenture holder and the company, and it clearly showed that the ultimate duty of a receiver, he owes it to the debenture holder and not to the company. Of course, also court noted that a receiver also has statutory duty to other preferential creditors. Of course, these creditors may include, government entities such as URA, NSSF, where they are preferential creditors and lining up also, and also any other creditors who may be secured or unsecured. But the ultimate duty is to the debenture holder, and then the other auxiliary duty goes to the other creditors. Court also held that a receiver has an obligation to retain for the benefit of the general creditors the net property subject to a floating charge. And this means that if a receiver is going to sell the properties, he or she must ensure that he obtains the best price for the benefit of the creditor, for the benefit of all the creditors. And of course, as lawyers, this is so important to us, because as insolvency practitioners, this duty, we owe it. Once you're appointed as a receiver, you must ensure that you run the business during that period, or if you're disposing of the property, that you do it in good faith to attain the best price for the benefit of the creditors and for the payment of the outstanding sums or loan. The other duties hinted on by court was a duty to act in good faith. Of course, this is expected of each and every insolvency practitioner once you are put into a position of a receiver. And this good faith also tackles in here in our theme of corporate rescue, because with this good faith, it's what results into corporate rescue, to help the company which is facing difficulties to come afloat, to pay off its debts and start operating normally. Now, we've already talked about the duty to obtain a proper price, which was emphasized in this by the Court of Appeal. Then the other obligation was the obligation to bring to an end receivership within a reasonable time. Court made a lot of emphasis on this obligation, because this is a receivership which had gone on for quite a very long time. And court felt that and noted that there was need to expedite receivership and to bring it to an end within a reasonable time. And this is the rationale why court went ahead to order the receiver to file an account and to sell the property and end the receivership within 6 months. Therefore, this is an important obligation, because any mode of corporate rescue cannot be indefinite. You cannot go on and on. It has to have an end, and this should be within a reasonable time. Another aspect was on liability of a receiver, and why this was in question. After appointing the receiver, there was an attempt to sell the property. However, that agreement which had been executed with Shumuk in respect of selling the property had been rescinded, and Barclays Bank had refunded the consideration that had been paid to the purchaser. So one of the issues which had been brought was on liability of a receiver in respect of such a transaction. First and foremost, court held that a receiver does not incur liability to the company. Court also noted that liability of a receiver is to the debenture holder and not to the company. And also court held that there is no liability for repudiating a contract in the names of the company executed by a receiver. But of course, it is important to look at the liabilities of a receiver under the Insolvency Act vis-a-vis what the judge held. So section 190 provides that a receiver is personally liable for any contract entered into in exercise of his or her power. So this provision, according to this provision, a receiver is liable for any agreement executed in his or her capacity as a receiver. However, we shall later discuss and look at the different types of receiverships, which are also discussed in court, and we'll also see whether these provisions cut across on all types of receiverships. Then section 192 provides court with powers to relieve a receiver from personal liability where court is satisfied that the defect in appointment of a receiver, where court finds that the liability was due to the defects in appointment of receiver solely, or where a receiver acted honestly or reasonably. But we shall discuss this further when we go to the different types of receivership. So court delved into distinguishing two types of receiverships. And this is a receiver of income, or sometimes called manager, and administrative receivership. Court noted that these are different and that administrative receivership came up as a result of law reforms in many common law countries. Noted that administrative receiver is expressly appointed under the law, and the powers of an administrative receiver are provided for by the law. And some of these powers include taking over and managing the company or business, running the business out of its difficulties and keeping it afloat, negotiating with creditors, disposing of unprofitable sectors of the business, eliminating unnecessary expenditure, generating income so that the business can be sold as a going concern, or reduce it into a form of a clean company. However, it should be noted that court clearly highlighted that this type of receivership was not the type of receivership in question in this case. However, it went ahead to try and distinguish and to make it clear on what is expected from the different types of receivership. Administrative receivership is provided for under Insolvency Act, and it is defined as a receiver appointed over the whole or substantially the whole of the property undertaking of a grantor, or a person who would be a receiver but for the appointment of some of other person as a receiver of part of a grantor's property. However, it should be noted that in the definition, the general definition of a receiver under the Insolvency Act, it includes all types of receivership. And of course, this is a bit challenging because when you're reading the provisions in the act referring to a receiver, then it means you have to read them in line with that definition to apply to all different types of receivership. However, the law, when it comes to administrative receivership, in some clauses specifically provides for powers of administrative receivership. So this is something which, calls for a debate on how do you sever administrative receiver from income receiver, and how do you sever the general provisions on a receiver under the Insolvency Act on the powers and the duties in the different types of receivership. Specifically for administrative receivership, the express powers of an administrative receiver are provided for under section 185(2), and they are in line with the distinction that was given by the judge, which is taking over the company, running it, For receiver of income, the court pointed out the receiver of income are appointed under an agreement, like in this scenario, the debenture. Then a receiver of income owes a duty of care to a debenture holder. The primary duty is to ensure that the unpaid credit is paid off. And there is limited duty to the company which the receiver is running. So the ultimate duty is owed to the debenture holder. So for receiver of income, the Mortgage Act provides for receiver of income under section 19, and it clearly provides for implied powers of a mortgagee to appoint a receiver of income in respect of the property that has been mortgaged. So this means once a mortgage deed is executed, then the mortgagee has powers to appoint a receiver of income in respect of that property, to run it, manage it, and to recover the outstanding sums. And according to this provision, you did not have to have a specific clause in the mortgage deed for the mortgagee to have these powers. But of course, in practice, and best practice is that a clause to this effect is inserted so that the mortgagee and the mortgagor clearly know under what scenario will a receiver of income be appointed, what will be the powers and the duties of such a receiver. Section 21, subsection 6 clearly provides that a receiver of income is deemed to be an agent of the mortgagor and not an agent of the mortgagee. Of course, this is different from what the judge noted in respect of to whom do you owe the duty, who are you liable to, whereby court clearly noted and held that the duties are expressly all to the debenture holder, and there is no liability that accrues to the company. What are some of the lessons do we learn from this case? First and foremost, as lawyers, we have to learn to pay an eye for details while drafting and executing these security agreements. You have to ensure that terms regulating the relationship between the parties are clearly laid down and understood by both parties. And on execution, all security agreements must be executed by all the parties, because one of the reasons why one of the security document had been challenged was because it was never executed. The mortgage deed was never executed by the bank. The mortgagors signed, but the bank never signed it. And it was argued that due to this, it was unenforceable. Although court did not agree with this argument, and court held that it was enforceable despite it not being executed by the bank, it is important for the legal practitioners to ensure that at the time of execution of such documents, we ensure that all the parties involved sign and execute, and the documents are witnessed, so that we avoid such scenarios where one of the parties is trying to walk away from such a document on the basis that it was not signed by all the parties. The second lesson is on integrity and accountability. We have to note that this is one of the core aspects that we must emphasize and have at the back of our mind: integrity and accountability. For any entity which is facing difficulty to be helped and to be rescued and put afloat, there must be integrity and accountability from the side of the insolvency practitioner who has been appointed to help this company and the creditors recover the money and to put the company back afloat. So whatever is done must be done honestly, and there must be accountability for any action undertaken. The other lesson is need to complete receivership within a reasonable time. So as once you're appointed as an insolvency practitioner, even in other types of insolvency modes, there has to be emphasis that the process must be ended within a reasonable time. It cannot go on indefinitely, because even the creditors must recover what is due or what is reasonable and put their books in order, other than having such debts continuing reflecting on their books. And also, even for the company that is indebted, it is important for it to either know and understand that at one point, that it's going to take over back the business and run it, or that there is no possibility of that, and therefore everything has to be liquidated so that what can be salvaged for the creditors and for the company is salvaged. So, and this has to be done within a reasonable time. And this is one of the things that we learn from this case, that receivership going on for all those years, ultimately it affects the value of the properties and what can actually be salvaged. For financial institutions, the lessons learned, just like the lawyers, emphasis on meticulous drafting and execution of security agreements. Banks have to ensure that all clauses regarding the relationship, events that might lead to appointment of receiver must be clearly outlined in the security agreements. The powers and the duties of the receiver must all be outright and clearly stated in the agreements to avoid scenarios like what was faced in this case. The other one is the role of insolvency in recovery. Like it was, we learned yesterday and we'll continue to learn, insolvency plays a cardinal role in recovery and survival of businesses. Not every time a company is in default or is facing financial challenges, not every time properties have to be disposed of. Insolvency, and with its different mode, is important in recovering what is outstanding, and also in the survival of the business. Because if you go outrightly to sell, you might not, depending on the market at the time, you might not recover everything. So it might not be in the interest of the bank itself to sell outright, because the bank might not recover everything that is outstanding. However, if, for example, a receiver is appointed, and the receiver, upon taking over business, realizes that actually he can run the business, or the business can be run perfectly, and all the monies that are due and owing can actually be recovered, and then after the business handed over to the owner, that would be a win-win for both the bank and the customer who is in default. So this case also shows the role, the importance role of insolvency in recovery, despite the fact that this is a receivership which went bad, which went sour, but it highlights the importance of receivership. Then the banks have to note that once they want to exercise the powers to appoint a receiver, such powers must be exercised in accordance with the agreements, security agreements, executed, must be done within the timelines provided for, must be respected, because one of the aspects here that was questioned was the allegation of backdating of the appointment of the receiver. The notices which captured crystal ways and not emerald, and because of such things, the parties had to reach where they are, and these are some of the things that the banks can learn, so that the next time maybe they're appointing a receiver, such things do not happen, which usually lead to litigation, like in a case at hand. Then the last one is the need for proper due diligence. One of the things that were discussed, were determined here, which we didn't want to go into details of because of the fact that some of our members are involved in the matter, resolve around unveiling a corporate veil, incorporating two companies with different names. So this, what the bank can learn from this case is to do proper due diligence to ensure that such a scenario does not happen. Then for judicial officers also, there are one or two things that you can learn from this case, and one of the most and important aspects is the need to resolve matters, insolvency matters, expeditiously. Having a matter involving receivership going on for 10 years, more than 10 years, 5 years, does not, in business terms, and even for the for the all purpose and intents of receivership, it defeats the purpose of receivership or any other mode of insolvency. So the judicial officers should not, they need to expeditiously handle these matters so that the creditor and the borrower's interests are protected, and so that the value of the properties which are subject to such a receivership is protected and is not wasted through lengthy litigation. Then also, courts are on the duty of enforcing the express terms of security agreements to basically respect the freedom of contract and the rights of the parties under such security documents, and also appreciating the role of insolvency as a mode of corporate rescue and the need for judicial activism. When you read this court, you clearly see how the lead judge was puzzled by the period that this case spent in the court system, the period that the receivership had gone on, and it reflects, and all this is reflected in his last decision on the disposing of the property within a short period of 6 months and the filing of accounts. So this shows that even in insolvency matters, there is need for some judicial activism reflecting on the role of corporate rescue and the need to protect the interests of all the parties. Thank you. That was all from me, the presentation.
Thank you so much, Solomon, for that wonderful presentation. We're going to check the chat in case there is feedback. Kindly requesting the IT team to display the screen. Okay. If there are no questions, we are going to go into our next panel. Thank you so much. In case there are no questions, we're going to take a short break for just 20 minutes. Then we'll reconstitute here at exactly 10:35 for our next panel, which will be at an in-depth discussion into the same case. So at exactly 10:35, shall be back. Thank you.
sorry, Bluebell Advocates. Sorry for that. Yeah. We also have Mr. Solomon Biolganda, also an insolvency practitioner, among other things. We are continuing the discussion of unpacking the case of Emerald Hotel. Before we begin, let me first thank Solomon for the insightful and thorough unpacking of the case earlier this morning. Your clear analysis helped to demystify a complex, a complex decision and highlighted its practical implications with remarkable clarity. We truly appreciate the depth you brought to the discussion this morning. Thank you, Solomon. To build on that enlightening presentation, I will invite Mr. Samuel Taremwa to take the discussion further. With his keen legal insight and practical experience, we look forward to your perspectives of the case. Welcome, Mr. Taremwa.
Thank you very much. Samuel Taremwa. I'm an advocate at Bluebell Legal Advocates. Excited to be part of the panelists to discuss this case. This case is beautiful in a way that it packages a lot of corporate governance issues. It talks about, as Solomon stated, lifting the corporate veil, receivership, breach of contract, and a lot of and other corporate governance issues. The Court of Appeal stated that this case is a sad narrative of a company which borrowed money from the FCU Bank, failed to pay it back, borrowed again got a second loan from Barclays, failed to pay it back, and defaulted. So the loan stopped making the commercial sense. Now, as we all know, in business, all businesses need credit. When you get credit, you have to pay back. When you fail to pay, insolvency comes in. When insolvency comes in, receivership. So this case covers all those topics. My take on this case is basically I want to talk about the emphasis that lawyers should take and banks on identifying the material clauses in these agreements in the credit letter, because the credit letter is the one that would stipulate the terms and conditions of the credit facility. So it is important that we analyze these provisions very well, because for example, in this case, whereas both parties were blaming each other for breach, one was saying the money I applied earlier to get this loan, then but the loan was disbursed later on, a month after I had applied for the loan. However, there were certain clauses in this credit letter that stated that the bank would not be obliged to make funds available to the client. So, which the courts, both the lower court and the Court of Appeal, relied upon to justify that these these monies were disbursed in time, and the bank didn't have a claim for the delay of the disbursement. Then this case also, there are also different issues of corporate governance. It also shows that the court can lift the veil on the directors of the company for their deceptive and fraudulent actions, even when they are not shareholders or directors in another company, as long as you fronted different persons to incorporate a company for purposes of borrowing. I can give an example. You incorporate a company, you're the directors, you borrow money, then when you notice that you're defaulting, you incorporate another company from different persons, then they borrow money. The court will be inclined to lift the corporate veil if they can draw a similarity between the two companies. And this is what happened in this case. Emerald Hotel was registered twice. So this confusion is what led to the lifting of the corporate veil. Even though the Emerald Hotel, the first one, the directors were different from the second one, but the court lifted the corporate veil because of the deceit and the fraud and the confusion created by incorporating two identical companies. So the corporate veil was lifted. It doesn't necessarily mean that for one to lift the corporate veil, you should basically institute a separate pleading, argue the grounds for lifting a corporate veil, but it can also be lifted within a suit that has different causes of action, as long as court would find there was fraud. Then there was the issue of I think the case also discussed about the issue of instruments that are not signed vis-a-vis a credit letter. Remember, I explained that a credit letter governs the terms and conditions of getting these loans. There were issues of when the default happened, one party was stating that this mortgage is unsecured. It's not a secured mortgage. Reason being that the mortgage deed was not signed, the charges and the debentures were invalid. However, what court emphasized was that the mortgage deed, as long as it's only signed by the mortgagor, it is valid. And also, even though, for example, the powers of attorney are not signed, some debentures are not signed, it doesn't take away the liability because the credit letter clearly stipulated that the mortgage was secured by a property. So a borrower cannot make afterthought decisions or defenses, probably because at the time of acquiring a facility, one of the documents were not signed. But as long as the intention, court basically looked at the intention of the parties. As long as the intention of the parties was that a certain property would be put as security, would be mortgaged, then that would be a secured mortgage, regardless of whether some of the documents are not signed by the mortgagee. Lastly, lastly, I think I should also talk about the issue of the importance of the court, the role the court played in trying to reduce on the liability of the bank, stating that a credit facility must make commercial sense. And once a credit facility takes lasts, then it no longer makes commercial sense and it's basically written off. And how the Court of Appeal tried to mitigate the further liability of the bank was to give small interest on the amount stated. Yeah. I think for now that's it. I think we shall continue having a discussion on the case.
Yes, thank you, Samuel. Now I would like to invite our online participants to join the discussion. Please feel free to post your questions or comments in the chat, or raise your hand, your virtual hand, if you'd like to speak. But as we wait for questions to be forwarded in the chat, let me again turn to Solomon. I invite your comments on one of the key takeaways in the judgments is to do with timely resolution of insolvency proceedings. This judgment serves as a critical precedent requiring timely resolution of insolvency proceedings. What practical steps do you see us insolvency practitioners taking to reduce on the length of insolvency proceedings? The judge, I think, rightly underscored the need to prevent delays that erode business value in these proceedings, the business value of companies in these proceedings. What practical steps would you advise practitioners to take to achieve that objective? Solomon.
Yeah, thank you so much. And like the judge emphasized on the timely conducting receivership and closing it in timely manner, I think it is so critical, and it goes to the rationale of why we actually have receivership. Because if you erode the value of the assets that are available, then you are affecting both parties. That's the creditor and the debtor, because it means the creditor will not be able, in the long run, if it goes on for a long time, will not be able to actually, recover what is due. Then even for the debtor, it means if the business is to go back to him or her or the company, then the business will be worthless. Or if at all you are disposing of the properties, then it means whatever would have remained as residue and which has to be given to the debtor, it means there will be nothing, there will be no value. So the emphasis on having timely receivership is so important, and it goes to the rationale and the purpose of corporate rescue. So in my view, as practitioners or insolvency practitioners, to ensure that we do what the judge advised, to ensure that receivership is done and closed in a reasonable period, I think first and foremost is to comply. You've been appointed, comply with the requirements. Advertise, notify the debtor, and one of the things, I think, if it is possible, create a good working relationship with the debtor. I know this is in most cases impossible or hard, because as we've seen this case, one of the reasons why this process and the litigation went on for all these years was because of basically the relationship, the sour relationship that was there between the receiver and then the data. So if it is possible, first and foremost, once you appointed and you notify the data, it is to work and try to create rapport or a working relationship with the data, because once you're coming into the business and the current directors of the company are relieved of their obligations and you are taking over these obligations, it is paramount that you know how this business runs, so that you run it effectively and within a reasonable period and recover what is due. The other thing is, first and foremost, immediately once you're appointed, to try and ascertain, do a report, ascertain about the affairs of the company. What are the assets and the liabilities, even for the other creditors who might not be the creditor who has appointed you, might be the preferential creditors or even unsecured creditors. First ascertain that, so that you determine, is the company a going concern or not? What is the probability of actually running this company back afloat and recovering what is there? Or is it too bad to the extent that you actually have to dispose of to get the best value of the properties, and you pay off the creditors and whatever is remaining, if any, after making all the relevant payments, giving it back to the debtor? And of course, depending on the size of the business, it is imperative to also, when you're coming in as a receiver, because we are receiver, but as a lawyers, you might not have some expertise in other areas. So here you might require services of some consultants who have expertise, for example, in valuing the business. Think if from the onset you have an understanding, a report on the affairs of the company, on its liabilities, you understand the sales, you understand the operation expenses, you understand each and every aspect, all the financial expectations, revenue, expenses. This will enable you understand and have an image of, is this business a going concern or not? Do I have to dispose of the properties to salvage what I can salvage at a good value for the interest of all parties or not? So it's something that cuts across, like I've emphasized, the relationship with the data. That one would play a vital role if it's cooperative, but as anticipated in most cases, the data will not be at good terms with the receiver, but then taking over the business and immediately conducting, whether using consultants or if you have existing staff who can help ascertaining the affairs, the correct affairs of the company, the proper books of account of the company, understanding the revenues of the company, the values of all assets and all the liabilities and expected expenses if you are to proceed with the business. That would help you, inform you to set timelines within which you will run this receivership or not. Because you cannot compare the time that will be needed for a company which maybe is valued at 10 billion Uganda shillings. You cannot compare it with the one which is maybe at 100 million. So each case is determined on its own aspects, but still these preliminary actions will inform on the period that will be needed for that specific entity for you to timely cross in and finish the receivership.
Yeah, thank you, Solomon. Samuel, a practitioner, what would be your advice on how on how to deal with debtors who are not cooperative in particularly receiverships? How do you deal with them and still ensure that you proceed and conclude a matter in a timely manner?
How it can be concluded in the timely manner, I think it also comes to the lawyers, the conversations you have with your client. If you notice that, yes, there is a default, the company is in receivership, then both parties, the directors of the company, which is in receivership, and the receiver, they should have a relationship to help the company be able to generate this income, because basically the purpose of receivership is to generate more income to pay off the debt. So if there is a good relationship between the directors and the receiver, and sometimes, as I've mentioned, you need to talk to the shareholders and the directors to be willing to work with the receiver. When there is that relationship, I think that it would help the process to take further, to easily be concluded. For example, in this case of Mland, you will notice that there was some friction between the receiver and the directors, and that's why probably it took long.
Thank you, Samuel. Let me get back to you, Solomon. This case emphasizes the need for transparency and accountability. We have also previously received judgments, but I'll particularly refer to the Supreme Court decision of Patel and others versus Wambuga. What are your thoughts about this concern again being raised by courts about the need for transparency? Are we learning the lessons that the courts need us practitioners to learn?
Thank you. The concept of transparency and accountability, we have to agree that it cuts across all aspects of life. And it's an important. There are important principles in whatever you do, because once there is no transparency, whether in governance, whether in politics, whether in practice as lawyers, whether at our homes, if there is no transparency and accountability, then it means you will not have anything positive. So I think this is the general picture that we should look at the concept of transparency and accountability. We should look at in that angle, because transparency comes from other duties that you have. For example, a duty to act in good faith. If you are acting in good faith, then automatically there will be transparency, there will be accountability. However, if you are not acting in good faith, then there will be no transparency, there will be no accountability. The other thing is understand what is your purpose. You as an insolvency practitioner who has been appointed, it might be a receiver, it might be a liquidator, or other modes which fall under insolvency. First and foremost, you have to first understand what is your obligation. What is the end goal? What is the rationale that you have been appointed? Once you understand that, then automatically it triggers transparency and accountability. Because if you do not appreciate that, then there is no way you will be transparent, there is no way you will be accountable to all the parties that are involved. It might be the secured creditors and secured creditors, preferential creditors. You must first understand what is your obligation, what is the rationale for your appointment, what is expected of you, and then with that it triggers into accountability and transparency. As to whether we are learning or not, of course we've not had a lot of issues dealing with accountability and transparency. This might be owed to the fact that insolvency practice in Uganda is still at infant stage. There are few entities you can point them with a finger which have been subjected to insolvency proceedings or receivership, administration. We at least know most of the main ones. So maybe because of this, that's maybe one of the reasons why we do not have a lot of transparency and accountability issues, but still, despite that, and of course sometimes the issues of transparency and accountability do not come to light, because sometimes once the entity is closed, the books are closed off, then it is hard to ascertain whether there was transparency or accountability. But as lawyers, I think we have to really learn and know that this is a cardinal expectation from us. This is one of the vital aspects that we have to always bear in mind when we are dealing with insolvency, for the good of each and every party that is involved, for each and every stakeholder in the insolvency proceedings. And once we appreciate that, then automatically we will have accountability and transparency. We will not have any issue with it. Then we also have to know what are the requirements of the law. When are we supposed to not give notices for appointments? When are we supposed to submit reports? What is supposed to be contained in those reports? Because transparency and accountability is reflected in those reports that are submitted. It is in those reports that the details of the figures, the details of the actions undertaken, that's where they are reflected. So once you understand your obligation, what is expected of you of filing these reports, what is supposed to be contained in these reports, then there will be no challenge dealing with issues of integrity, transparency, and accountability. Thank you.
Yes, thank you, Solomon. Once again, I invite our online participants to also get involved in the discussion. Please share any comments that you might have on the online chat. Our IT team will be able to relay them to us and will respond. This case obviously also has implications for not only insolvency practitioners, but also for financial institutions and for borrowers. It reinforces the principle that borrowers must honor their financial obligations, and also lenders must rely on terms of their contracts to recover debts. Samuel, and obviously Solomon as well, would you like to share with us your experiences in this particular area? I know you're experienced, seasoned practitioners. What is the court saying here regarding this obligation for particularly financial institutions, that they must rely on terms of contracts to recover their debts?
The courts are more inclined to the contractual terms of these credit facilities, and they would be interpreted as is. For example, like in the Emland case, as I mentioned before, one of the provisions in the facility was that the bank would not be obliged to pay the funds immediately, and I think this was really disputed by the party, by Emland, which said that the breach of the bank came as a result of delaying to disburse this money. But in court, when court was interpreting this provision, it was more inclined in protecting the bank, but based on the terms of the agreement. So I believe the court would be more inclined on the terms of the agreement. However, the parties, the borrower and the bank can always enter into restructures, which I think would make sense for the business, because it would continue operating other than going for receivership. Yeah.
Yes. Solomon?
So, of course, court's duty in enforcing the terms of such creditor agreements, it cuts across the approach court has when it comes to enforcing express terms of a contract. It is not the duty of the court to contract on behalf of the parties. Court guards jealously the doctrine of freedom of contract, unless there are exceptions which court will try to intervene, like unconscionable bargain or other thing. But courts in all types of contracts protects this freedom jealously, and this spills over to still in these facility agreements. Once parties agree, the lender and the borrower agree express on the terms of the advancing the facility, and they are laid down maybe in the offer letter or in the mortgage or in a debenture. Court will read them as they are and enforce and give them effect. Of course, in practice, we realize that always when the borrowers get financial challenges and try to challenge the facility, they will try to challenge some of these terms or try to raise allegations of certain facts or certain terms which actually are not expressly stated in these facility agreements. But courts have already shied away from such and strictly enforced these terms. And of course, this calls for lawyers involved, whether representing the borrower or the bank, and even in-house lawyers for the banks, to ensure that all the terms agreed upon, they are clear, laid down in the facility agreements. Because when it comes to enforcement in court, courts tend to enforce them as is. So it is important to really tie down on each and every term that you've agreed upon, what triggers default, what are the payment terms, what is the interest rate, what are the securities that will be that will secure the monies that have been advanced.
Thank you. This decision also underscores that courts will look beyond corporate structures when they are used to perpetuate fraud. I don't know how this decision compares to others that you're familiar with, Samuel and Solomon. Is this a welcome direction we are taking? There is a case, I think, from the High Court in Kenya where courts stated that, I think it is Postbank, something. Sorry, I should have written it down and prepared better. But are you happy with the direction of our jurisprudence in this area? And here, I invite you to speak generally. Are we getting better? You can speak.
I think, personally, I think it's a fair decision, because you will notice a company is literally a separate legal entity from its directors and shareholders. So the decisions that are made by the directors are made on behalf of the company, despite it being a separate legal entity. Now, if these decisions are not in the interest of the company or are fraudulent, deceptive, then they would lift the corporate veil. However, there are instances whereby the corporate veil would be lifted because of fraudulent transaction between related companies or associated companies that are associated to each other. For example, you would find in one company, the shareholder is a person is a shareholder in one company and a shareholder in another company. Then they would use the other company to probably do all the fraudulent transaction, probably evade taxes and all that. So court will be inclined to lift the corporate veil based on the fact that you're using another company to shield the fraudulent action of this other company. Then there are instances, for example, in this case, the directors of the company, of the hotel, incorporated another company and fronted different directors in that company, but they were not shareholders in this scenario, nor were they directors, but they are the owners of that company. So it was just a matter of just linking the distinction, the relationship between these companies. And when you link such relationship between these companies, you will notice that these other companies, instead of having a sound corporate structure, carrying on business normally, they are just using them to for probably things that are not in line with the company objectives. So I think lifting a corporate veil, the decisions that have been decided by court in lifting a corporate veil of related companies, associated companies, is fair, because also it's somehow common that people in business nowadays are using different tactics to do actions not in line with the company objectives. So court will always find ways to lift the corporate veil based on the case-by-case basis, which I think is fair.
Yes, as we conclude this discussion, Solomon, any final thoughts?
I just wanted to just note some things on the last question that you posed regarding corporate veil, and whether the decision is welcome in that respect. First and foremost, I have to emphasize that what court stated and is what has been there, is what Section 20 of the Companies Act provides for instances of unveiling the corporate veil. These are things that courts have to always look into and to see whether there are circumstances justifying the unveiling of corporate veil. Of course, other court cases have clearly stated that the provision or the grounds contained in Section 20 of the Companies Act are not exhaustive, as long as there are facts which clearly shows that there is fraud, or the company is just a mere sham, just being fronted for and on behalf of the shareholders to perpetuate illegalities, that courts will always come in to lift the corporate veil to reach at the ultimate beneficiaries. Of course, this is the exception of the principle in Salmon versus Salmon. So people have to know, or parties, or even us lawyers, that the issue of the corporate veil, you cannot always hide behind that veil. There are a lot of instances where courts can actually just remove the veil to reach at the ultimate beneficiaries behind the company, and that is justified in the facts how courts went on the issues of deception, misrepresentation, to really say Crystal Airways and Emerald Limited, there is no difference.
Yes, as we come to the conclusion of the discussion, what are your final thoughts about this case and its implications for stakeholders? Starting with you, Samuel. Any final thoughts?
My final thoughts is for the bank. My final thought is that for the banks, they should carry out more due diligence while entering into these agreements. Then also this due diligence would help them determine issues to do with security, and also to enter into very legally binding agreements that would not be challenged as afterthoughts by borrowers in the event of default. For the borrowers, I think it is important that there is transparency, because if there is transparency, then there is a good relationship between the bank and the borrowers. and also comply with these agreements, other than continuing to only pay the interest. Also, it's important that the principal is paid, basically comply with the agreements. Then I think for the market generally, for everyone, I think the agreements, when they are strict and are binding, I think they support enforcement and implementation. Yeah.
Yes, Solomon.
My final thoughts. This case clearly reaffirms the right of banks or creditors to appoint a receiver. It reaffirms the powers of a receiver and the duties and obligations and the liabilities, and it also highlights the purpose of receivership in corporate rescue, where it is handled well, that actually a lot can be salvaged. It also calls upon us as insolvency practitioner and other legal practitioners to emphasize transparency, accountability, and also to handle receivership or any other mode of insolvency in a timely manner, so that a lot is salvaged, that there is value for the creditors and even for the debtors. So as of now, it's a decision which has been welcome in line with insolvency. Yeah.
Yes. On behalf of the Uganda Law Society, I thank you, Solomon and Samuel, for this insightful and thorough unpacking of this case. Your clear analysis has helped to demystify a fairly complex decision. Earlier on, when I was talking to Samuel, he was reminding me that it is about 200 pages. And the one in High Court was how many pages? 130 pages. So thank you for bringing clarity to this complex case and highlighting its practical implications. We truly appreciate the depth you've brought to the discussion. I would also like to thank the audience, our online participants, for your patience. Thank you for your sacrifice and time you've put in to be with us today. I now hand back to our secretariat.
Thank you so much, Moderator, Mr. Ruta Darius, and thank you to our esteemed panelists for the insightful discussions on the Emerald case. Yes. So next up, we're going to invite, we're going to the next speaker on the agenda this morning and afternoon, and that is none other than Mr. Paul Winnie Kasami, and I'm just briefly going to read his bio. So Paul Winnie Kasami is a senior associate at Legomark Advocates, specializing in insolvency, business restructuring, and commercial litigation. He has advised on high-profile receiverships, liquidations, and business rescues across various sectors in Uganda. He is a member of the technical committee of INSOL International Future Leaders, and he lectures at Makerere University Business School. Paul holds an LLM and is currently pursuing an MBA, bringing a strategic and interdisciplinary approach to insolvency law and practice. So, ladies and gentlemen, I'd like to welcome our speaker, Paul. Yes, so this afternoon, Paul is going to be delving into insolvency in the digital economy, dealing with emerging business models in Uganda. Yes, we know that the current generation we are in and we're going into is, a highly digitized, generation where everything is shifting into the digital era. So Paul is going to give us insights on what is the future of insolvency in the digital era. Yes, so over to you, Paul.
Thank you. Good morning to the members online, the members of the profession, the insolvency practitioners out there. I greet you. As introduced, I'm Paul Onyekasami, and I'm happy to have a discussion with you today on a very interesting topic, a topic that I think in the time that we are in is very relevant, seeing as most of the insolvency that we practice is based on traditional business models. So today I'm going to be looking at insolvency in the digital economy with a focus on the ecosystem and how each of the aspects of the ecosystem interact with one another, and the challenges and opportunities that arise from the interactions within the ecosystem, and how we as insolvency practitioners can tap into the opportunities that have come with these emerging business models, how we can address the challenges, and what skills we need to ensure that we remain relevant in the long run. So I usually make it a habit to start whatever I do at the beginning of every day with thanksgiving to my Creator, and I pray that the wisdom and knowledge that I share today will be to His glory and not to mine. And yes, this is for His glory. So we shall dive right into it. So for today's discussion, we are going to have an introduction to digital transformation and insolvency. The focus is going to be on Uganda. We are going to look at the emerging business models and the risks that arise therein. We're going to look at the dynamics of insolvency, stroke distress within in the digital era. Then we'll have a brief look at the insolvency framework, because this one is fairly known to the bulk of us. Then aligning with the theme of this conference, we are going to look at the stakeholders as catalysts, and then we'll look at the available business rescue mechanisms within the digital ecosystem. We'll look at the challenges and opportunities, and lastly, I will look at the skills, the key skills for the digital age insolvency practitioner. Oh, sorry. So, for our introduction, I felt it important for us to start with the ecosystem. And why is the ecosystem important? The ecosystem is important because before you analyze systems or before you provide solutions, especially where there are a number of stakeholders involved, it's always important to know how each of these stakeholders interconnect with a view to achieve a desired end. So for every business as we know it, be it digital or be it under traditional model, there is always an idea at the beginning. There is always an inception to this. And what informs the business idea is the problem that you're trying to solve. You have entered into a society, you found that there's a problem of integrating payment systems, you found that there's a problem of financial inclusion, to mention but a few. You're trying to connect a number of sellers who are located in different parts of Kampala, and you're putting them on one platform for them to interact with with a client base that also has access to your platform. So the idea that you're forming is what informs the entire ecosystem. It is the foundation of your entire ecosystem, because on the basis of the business idea that your clients are coming to you with, as an insolvency practitioner, as a lawyer, as an accountant, the legal and regulatory infrastructure and everything else will be dependent entirely on how they can achieve their business idea. So key to the business idea is also that as the decision is being informed on how to proceed forward, you will want to build a resilient system. A business idea is not meant to last only 1 year. Usually business ideas are stretched over a period of 5 years and more. So because of that, the entire ecosystem is also looking at how to build a resilient system. Resilient in terms of the legal framework, resilient in terms of the regulatory infrastructure, the financial structuring, and so on. So when we are looking at, again, the business idea, we usually ask ourselves, what are those things that inform the business idea of a person who has come to you and they want to set up a digital business? And you will notice that there are quite some obvious differences between the traditional business model and the digital business model. Now, because of those differences, for example, the core proposition of the traditional business and that of the digital, because of those differences, it informs how even we as insolvency practitioners or as advisors to the clients that we are serving, it's going to inform the kind of advice that we give them and how that advice is going to be structured. So you're going to find, as we go into this presentation, as we go deeper into this presentation, that the characteristics of digital businesses are partly the reason as to why it's important for us to have this discussion. Just as an example, you will find that the traditional business model is heavily backed by fixed or physical assets. And yet, when you look at the digital businesses, these are asset-light companies. Asset-light meaning that there are few assets, or as we call them, the intangible assets, assets that you can't physically perceive. So because of that kind of layout, because of the differences between digital businesses and the traditional model, it also means that the way we interact with this ecosystem as insolvency practitioners has to change. And later on in the presentation, I'll be showing you how that happens and the skills that we need. So when the business idea has become clear, the rest really, I think, is self-explanatory. We have the legal and regulatory infrastructure and the financial structuring and resilience. This is the point where, you know, you're deciding the kind of corporate structure you're going to have within the entity and how you're going to raise capital going forward, whether it's going to be equity finance or debt finance or other modes. Then once you have resolved the second pillar, you move up to the digital assets and the intellectual property governance, where you establish the structure and the manner in which the digital assets are going to be held, how you're going to build the portfolio and the governance around the portfolio. Then above that, we have the governance compliance and the ethical design. What are the checks and balances to ensure that the framework that you're coming up with is transparent, as the panelists before highlighted? What are the structures in place to ensure that the digital system operates with a level of integrity that promotes confidence amongst investors? And then we have technology, innovation, and adaptability, which is obvious to digital businesses. And then at the top of it all, we have stakeholder engagements and then insolvency resilience. So stakeholder engagement is at the top, because you can't have stakeholder engagement when any of the things below are uncertain, including the business plan. It is difficult for a digital business to pitch to a stakeholder or to pitch to a creditor, whatever strategy they have, for example, for a business restructuring or things like that. So on the side of the pyramid, I have a few examples of what digital businesses would look like. You have e-commerce and cloud services. You have the ride-hailing apps, our Uber and SafeBorder. You have platform-based businesses, and so on and so forth. So just a brief history, or just looking into where we are as a nation. We will notice that, especially since NDP 3, the National Development Plan 3, there has been a very vigorous focus on digitizing the economy. This is largely because ICT is viewed as a key enabler of socio-economic development within the country. So based on that, based on the renewed focus of government being a key stakeholder, ideally the entire economy is going to follow suit. So because of that, what do we have? We find ourselves having rapid digital transformation. Either people are playing catch up, or the ones that are joining the market are preferring to have hybrid systems, hybrid between traditional and digital, or you have some that are doing exclusively digital, where they, for example, do not even have premises. There is also a renewed focus from URA. If you pay attention to how they're getting involved in digital businesses. As a result of the rapid digital transformation, there is also a focus on the stakeholders to see how they are equipped to manage the emerging risks that we eventually see. But when this revolution is properly managed, then we find ourselves building a resilient ecosystem for digital businesses. So that explains the cap at the end. So what are the key drivers and what are the contributions in as far as the digital economy is concerned? Amongst the key drivers, and also still within the ecosystem and stakeholders, we have the fintechs and e-commerce. We have the mobile financial services that fall under the fintech. We have MTN Momo, we have Airtel Money, and these are giving access to finance for the unbanked citizens of Uganda, access to transactions, access to savings, and this is fueling a lot of online commerce and entrepreneurship. We also have e-commerce platforms, for example, Jumia Uganda and SafeBorder. SafeBorder is now, a multi-faceted platform. They're in fintechs, they're in delivery of packages, ride-hailing, the border borders, and so on. So they are changing how Ugandans are shopping, they are changing how Ugandans are traveling, how they deliver goods, with a central theme of convenience. And mind you, these things are inevitable. As you can see, we are slowly moving out of the traditional mode of doing business, and everything is now going digital. So I did mention that there's also a renewed focus from government. We have the National ICT Policy and the Comprehensive Digital Transformation Roadmap that is stretching from 2023 to 2028, which is primarily aimed at nationwide broadband access, improving digital literacy, and also enhancing the cyber security infrastructure. So, as these are the key drivers, we are seeing that the contribution of digitization is quite large. We are seeing a boost in employment and GDP. I recently got to learn that as of 2003, there were over 23 million users of, I think, registered on the mobile money platforms, and over 2.3 are benefiting from employment within the sector. And those are key statistics, because they inform how we view or how we interact with the digital with the digital ecosystem. And they also inform, the challenges that are faced. Later on, we are going to be seeing why, for example, there has been reduced absorption of, the citizens into the digital economy. Lastly, of course, as a key driver, we've talked about internet and innovation. We are seeing, innovation hubs are coming into place to catalyze the digital expansion and necessitating supportive policies and regulatory frameworks for sustained growth within the digital economy. We'll talk more about this when we look at the regulatory framework. So, What then are the emerging business models and the risks that are associated with this? So when we look at the, just give me a minute. Yes. So when we look at the different digital businesses that we usually deal with, we find that the largest number of them are platform-based. And what do we mean by a business being platform-based? If I may use the example of Gigi, which I think most of us are familiar with, you know that Gigi does not have a shop, Gigi does not have a mall, but it is a platform on which a number of users are interacting. You have users who are probably sellers, you have those who are brokers, you have those who are looking to purchase, and they're all interacting on the platform. So the largest category of business models that you're dealing with within the digital economy are platform-based. And what does that mean? That means that they are asset light. So all their operations are asset light. So it's unlike your traditional business model where a company owns land. It's unlike your traditional business model where the company owns motor vehicles and things like that. The primary asset, as we are going to see later on, is essentially the IP, it is the source code and things like that. So when we're dealing with platform-based models, we see that we have enabled quick scaling, there is a broader reach, and because of the speed at which platform-based businesses grow and scale, the challenges also rise at a very exponential rate. So you have issues to do with risk management and compliance strategies being robust, with a view to to keep up with the growth, but also with the challenges. Another category or another characteristic of these businesses is that they are involved in cross-border operations. We know that Jumia is cross-border with operations across Africa. And because of the cross-border operations, you're dealing with a digital business that is operating in more than one jurisdiction. So just the complexity of that network, just the complexity of how to deal with things like market access, how to deal with international cooperation, how to deal with regulatory alignment in the different jurisdictions becomes a bit of a problem. And that's why there has always been a renewed move, especially amongst countries that subscribe to the UN, to adopt the cross-border insolvency regulations, the model law on cross-border insolvency and practice. It is a unified law, so it is a unifying law, harmonizing the different cross-border elements with a view to provide a bit of certainty to management of insolvency proceedings across the board. So within the digital economy, this is one of the characteristics of the businesses we are dealing with. So I already talked about the examples we have. We have Safe Border, we have Jumia, we have Market by Momo, and these exemplify successful digital ventures, spotlighting the innovation, but also the potential operational vulnerabilities. So what are these vulnerabilities that we are talking about? I did mention that there's a scalability challenge. Because of the speed at which these companies are growing, the speed at which they are scaling, sometimes you find that they are scaling faster than the resources that they have, particularly finance. They are scaling faster than the corporate governance within the organization can handle. You find that someone came up with an idea, perhaps it was something that is trending, and because it is trending, someone wants to set up a digital company that deals with ESG or things like that. So you find that because of the limited resources, much as scaling at a fast pace is good, the scalability challenges are related to the available resources and the infrastructure. So at the end of it all, the operations and the infrastructure of the business are stressed, and that leads to instability. We have the data privacy concerns, which are well known to all of us. There is a lot of data that is shared every time, you're trying to order an Uber. You can't order the Uber without an account. So ideally, you have to sign in either with your Google account or your Apple ID, and you can't help but wonder what your data is being used for. And I'm very sure some of you are, browsing the web or something, an ad appears and you wonder how they knew what you were thinking. But, that speaks to the data privacy concerns. And of course, the all too notorious fraudulent activities that have made the news time and again, which are also part of the vulnerabilities that the ecosystem has to deal with. So, what are the distress dynamics in the digital era? And I use the word distress because what we are looking at today is rescue. Distress is the point before insolvency, where you notice that something is wrong and it is time that you consult an expert to come and look into your affairs with a view to get you out of the problem. So the first thing that we notice within the dynamics is we have evolving triggers. And what we mean by evolving triggers is that what once caused or what is currently causing insolvency within the traditional model is not what you're going to find as the direct cause of insolvency within the digital economy. So, of course, our first comparison is the traditional versus the digital triggers of insolvency. And you'll find that for the traditional insolvency triggers, we had things like prolonged losses, we had cash flow mismanagement, economic downturns. And while these still apply even within the digital ecosystem, they are not the primary cause of insolvency or of distress. But we have found that the most, especially when you're running the comparison between traditional and digital ecosystems, just a glitch, just a change in the code, just a word that, there's something wrong with this app, or the app just shutting down, causes immediate insolvency, which you would not ideally have within the traditional framework. So the sudden shocks are going to be more prevalent within the digital ecosystem and not as we would have expected them in the traditional. Another new dynamic, of course, is the high degree of informality among the businesses in Uganda. Most of the businesses are operating without a corporate structure. Most of the businesses are one person shows, whereby if the person dies, so does the business, and things like that. And we find that this is also a problem that has stretched into the digital economy. It is one person with the vision. Okay? So many tech startups and online entrepreneurs are operating informally. They're operating without robust commercial corporate structures. And as such, there is no corporate structure through which finance can be channeled. There's no corporate structure that can handle the management of distress. There is no proper bookkeeping because, excuse me, in order for you to, to identify the evidence of distress, there has to be some kind of source information. So without even having books that are keeping records of what is going on, the high degree of informality within the business model becomes a trigger for insolvency or of distress within the digital ecosystem. And then lastly, of course, we have the issue of lack of physical assets. The economy as we know it relies heavily on physical assets. Creditors want to see something that they can feel and touch, something that they can sell, and it becomes very difficult to explain to an intending purchaser of a distressed company that you're selling to them a trademark. The level of explanation that you'd have to put into selling a trademark is not the same as the explanation you'd need when you're talking about selling land. So as part of the evolving triggers, we are seeing that for digital businesses, the lack of physical assets becomes a trigger to the insolvency because it is very difficult to have a conversation with a creditor along those lines. But like I said, these are always opportunities. As I have mentioned, innovative valuation measures and asset tracing techniques do come in to keep us relevant. We then look at the recovery complexities that are involved within the ecosystem. Like I mentioned earlier, because of the kind of business model that you're dealing with a platform-based business, and then you're also dealing with an asset-light business. So those are the two primary characteristics of the digital business that you're dealing with. So there is always an issue of recovery. How do you recover an asset that you can't see? You're recovering an asset that is invisible to the naked eye. And therein lies the catch, where you have to have some kind of specialized experience in tracing digital assets, in analyzing business models, ensuring that whatever procedure you deploy, whether it's a business rescue measure or whether it's an insolvency proceeding, it ensures a fair and effective resolution process for all the stakeholders that are involved. Also, when it comes to the digital asset treatment, we do have a gap in as far as specific regulations for digital asset treatment are concerned. I think the law that came so close to doing that was the SIMPA, the Security Interest in Movable Properties Act, which has a definition of intangible assets. But I do know that amongst us there are those who believe that it could have been expanded beyond what the current definition holds. So having specific regulations that relate to digital asset treatment creates an uncertainty, and of course the uncertainty stretches as far as how to treat such assets in cases of insolvency, how to prepare a plan based on the existence of those assets, how to treat those assets, and so on. And then lastly, of course, the recovery complexities also look at e-platform failures, which really emphasizes the need for better protection for those that interact with these platforms. Like I said earlier, you wake up one day and the app can't open, yet it's your digital wallet and things like that. So based on these recovery complexities and at least what we have discussed up to now, it's quite clear that the digital era in Uganda is redefining how we do business, how we interact with one another, how our clients interact with one another. And I'm sure as lawyers, you have also witnessed this. Some of your clients are interacting with you more frequently on e-platforms than they are physically. So based on that, the insolvency framework needs to contend with the ever-evolving and the fast-moving crisis, the ever-growing portfolio of intangible assets, contend with the informal operators within the digital sector, and the stakeholders like platform users. For example, if I asked any of you how you would categorize a platform user when it came to determining the kind of creditor that they are, looking at the definition of who a creditor is, becomes quite interesting. So we are now finding ourselves in a situation where we are dealing with an ecosystem, or we are dealing with users that we are not part of the traditional creditor data picture under the current insolvency regime as we know it. So these new dynamics, of course, make a very persuading case for coming up with an adaptable insolvency regime that is viable for digital businesses, and especially in as far as business rescue, distress management, and insolvency proceedings are concerned. So with that, we then look at what the framework does for us at the moment, and what reforms may be necessary in the grand scheme of things. So since I'm speaking to lawyers, I really don't need to dwell a lot on this. The Insolvency Act is well known to us, with the recent introduction in the red volumes under Cap 108. And later on, I'll be highlighting one of the most welcome amendments that is relevant to business rescue, still with a focus on digital businesses. So the inclusion of the Insolvency Act is not by mistake, but its relevance, especially in the mechanisms that have been put in place for business rescue, are quite critical. Then, of course, I have mentioned the gaps that remain: the treatment of assets, the classification of intangible digital assets, and things like that. We have the likes of data sets, we have the likes of domain names, cryptocurrency holdings, and so on. So, however, even with these gaps, there is always, where there's a will, there's a way. And the way within the Insolvency Act is for us as insolvency practitioners and as business rescue specialists to make use of the application for court's directions. There are a number of my seniors who always say that when in doubt, consult the court. So where you find yourself dealing with a couple of gray areas in the law, where you find yourself dealing with digital assets whose treatment you cannot properly state, or where you basically find yourself having to think through an action before going ahead with it, seek court's directions. So in the meantime, while we wait for the gaps to be plugged by continuous reform, since we are now talking about an adaptable law, it is on us as insolvency practitioners to also build the jurisprudence in the area of the management of digital assets in cases of distress and in cases of insolvency through the applications for court's directions. So I've talked about the needed reforms, regulatory clarity, specifically on the kind of assets you're dealing with, the regulation around digital assets, the regulation around digital companies, because at the end of it all, it's going to enhance investor confidence. And it's quite clear that digital businesses really require a very high level of confidence, especially when it comes to capital raising. The needed reforms also include cross-border measures, where we find that the platform-based business is operating in more than one jurisdiction, and perhaps that other jurisdiction has not yet adopted the ancestral model law on cross-border insolvency. We are at liberty to be creative, coming up with memorandums that allow for the interaction between practitioners appointed here over the assets of, let's say, the parent company or a branch or a subsidiary, and the ones appointed in the other jurisdiction, and also addressing the gaps within the treatment of digital assets and the regulation around that. So those are the reforms that we hope to see eventually. But like I've said, in their absence, the wheels of the car must keep turning through the application for court's directions. So, in line with the theme of this conference, you can't have a conversation about the digital economy without looking at who the stakeholders are and how they can act as catalysts for business rescue within the digital ecosystem. So successfully navigated insolvency in the digital economy requires a multi-stakeholder effort. And of course, amongst the stakeholders, we have the government. I have mentioned the role of government and how it has at least given us the blueprint of where its focus is. And it's on us to distill what the government has really put down in fine print. Still under government policy, we do have the regulator. There is a renewed focus from URSB in as far as business rescue is concerned. Very, very key to the stakeholders are the financial institutions. And why do I say that these are very key? Almost all the private lending to digital, within the digital business ecosystem, comes from banks. Well, we have banks and of course other lenders, but the theory is the same. At the end of it all, money has been disbursed, money has been injected into an idea. Remember, at the bottom of the ecosystem, we talked about the business idea. What is that problem that you're trying to solve? So in trying to raise capital, banks and other lenders are the ones that you want to convince, to jump on board. So as key stakeholders, the role they play is not only that of extending capital or making financing available, but they also act as creditors when they are on the other side. They are creditors in insolvency, creditors in distress, and also providers of credit. So their relevance, especially in as far as business rescue is concerned, is their participation in workout programs, debt workout programs, where you're trying to come up with a plan on how to repay your debt. Banks and the lenders are critical to the success of whatever plan you come up with. There are plans that are usually prepared as reactionary measures to actions by banks, or where there's a bit of a fear. But in such moments, it's always important to ensure that even as you're preparing your plan, be it reactionary or be it with a view to save the business, then the banks, and especially the core banks that are involved, or the core banks that are classified as key creditors, for example, secured creditors, are involved in your plan. Later on, we shall be looking at the hybrid approach to business rescue, where I lay out just 3 brief steps on how to achieve a hybrid approach to business rescue. And then, of course, lastly, within the ecosystem, we have the insolvency practitioners and the judiciary. And basically, we, as insolvency practitioners and as the judiciary, together with the judiciary, we act as the custodians of the rescue process. We are the ones who advise, we are the ones who draft. So essentially, clients are depending on us to rescue their businesses or to prepare for their orderly exit. So we are custodians of the rescue process. So what does that mean? It means that we need to stay informed, and by staying informed, especially about the digital industry dynamics, and being willing to employ the flexible tools that are allowed by the law. For example, I talked about the application for court's directions. We are catalyzing successful restructures. We are providing for the orderly exit of those that are too gone to save. Then I still within the key players, of course, we have the entrepreneurs and the digital platform operators. We have the civil society, academia, and the public involved. So what then does that mean? With all the players involved, with all the the members that we have talked about, there is need for a more collaborative ecosystem. If we are really intentional about achieving business rescue, achieving distress management, achieving the orderly management of insolvency proceedings within the digital economy, what is required of us is to have a collaborative ecosystem. So within this collaborative ecosystem, we need to enhance entrepreneurial governance. We need to enhance financial literacy, and we have to leverage the partnerships. And these partnerships are partnerships amongst stakeholders, not just amongst insolvency practitioners, but stakeholders who are involved in innovation. We have the likes of Innovation Village. We have to invest in knowledge sharing. We have to be collaborative when it comes to problem solving. Okay? Financial literacy, we have to ensure that as these businesses are mushrooming left, right, and center, the people behind these companies, or the people involved in these companies at whatever stage, whether it's at the tail end or at the beginning, at inception, it is important that they are informed of the decisions and responsible financial management. You will recall in our pyramid structure, the legal and regulatory were at the same level as the financial structuring of the entity. So it is key that at that level, at the level before even the stakeholders are brought on board, there is a demonstration of financial literacy from those leading the organization. And of course, entrepreneurial governance goes without saying. It is important to have people at the top that have at the center of all their decision making sustainable business practices. So, for all that I have mentioned, it is quite clear that as insolvency practitioners, we require a unifier for all this. Divided we fall, but united we stand. And I think the discussion has been going around for quite some time about, who should be at the forefront of pushing for such reforms in the law, who should be at the forefront of causing a shock within the industry to ensure that we stay up to date with the things happening within our practice. So, one of the reasons as to why there is a desperate need for an industry unifier is due to fragmentation concerns. The sector currently lacks a central coordinating body. The voice of the practitioners is basically in corridors. We need a body that will serve as a unifying voice, advocating for the interests of insolvency practitioners across various disciplines, including development of our skills within the digital economy, and then also a unifier for purposes of industrial growth. And I do believe we have all heard this before. The Uganda Association of Insolvency Practitioners. I am aware that it exists, but it is time that it wakes up. So, we now look at the business rescue mechanisms. And these business rescue mechanisms apply both to the traditional models and to the digital businesses, of course with a twist. Like I said earlier, for example, you may have an administration, but within your administration you have to be very ready to deal with the shocks that you're going to find, especially in a digital business. Like I said, how are you going to be treating the assets? How are you going to classify the assets? How are you going to treat the user platform that you find within the company and things like that? So we already have the formal mechanisms which are known to us in the law: administration, receivership, restructuring, and so on. We have the informal tools which look at mediation and the hybrid tools, providing flexible options for resolving disputes and restructuring debt. And then the most important, the most important, the one which I must emphasize is at the heart of business rescue, is early action. Early action is really important. Like as I mentioned earlier, it is very difficult for you to find someone is terminally ill and you want them to come back to full health. But early intervention avoids that. You're at a point where there are signs, you're at a point where there are symptoms, and you're raising the flag early enough to say that there is a problem here that we need to resolve. The code is not functioning the way it should function. Users are complaining on Google and giving us a 3.5 star rating instead of a 5 rating. What are they complaining about? Your app is always shutting down and things like that. So the importance of early intervention cannot be understated. Across all mechanisms, one lesson is clear, that the earlier the rescue mechanism invoked, the higher the possibility of saving the digital business. So we need to encourage our clients, instead of rushing to court to get injunctions, the moment there is any hint that there is a problem with the business, things like your brand being destroyed on social media, that is the point where an early intervention measure should be deployed. Okay, where you have people that manage the PR and things like that. So it really calls upon us to be. These intervention strategies also require a bit of innovation. So I did mention that I would hint on the hybrid approaches, and I structured it in 3 steps. The first step would be the mediation technique. So within the mediation techniques would be allowing for the resolution of disputes, fostering a consensus among stakeholders. You bring the stakeholders to the table, understand what the problem is. Where has the challenge been? Has it been the code? Has it been the way the product is published on the website? Has it been this? Has it been that? And the beauty with managing stakeholders is that it gives the stakeholders the reassurance that we are with you in this. We are not hiding the problem. We are aware that there is a problem, and we are willing to work with you to ensure that we do not have a reoccurring situation, or we find a better way of doing this. This you'd find commonly with the fintechs, connecting different payment platforms and users, and maybe there's a problem with the fintech. You'd want to call the banks that are channeling payments through the fintech, and you want to sit with them and say, we have seen that there is a problem, we are working on the problem, this is what we have, what do you think about it, and things like that. So the mediation technique ideally helps to to cool the tempers. You're pouring a bit of water on the fire, and that is your step one. And then step two, once the problem has been made clear and the solutions have been proposed to the stakeholders, you now have a collaborative restructuring approach where you're enhancing the transparency and fairness of whatever process you intend to take, with a view of promoting trust amongst all the parties involved. So you've started by mediating the issue. You have opened up and explained what is going on, and you're displaying a willingness to work collaboratively with all the stakeholders involved with a view to achieve a desired end. And then finally, through the collaborative restructuring, we expect a tailored solution. And this tailored solution is not only serving the interests of the digital business and its sustainability in the long run, but is also serving or protecting the interests of key stakeholders, for example, the creditors. So it exponentially increases the likelihood of a successful business restructure within the digital economy. So then, what are the challenges that we are likely to find? Like I mentioned, we have issues of governance, we have digital illiteracy, and then we have legal uncertainty. I did hint on these during my presentation, and I think it is quite clear. Of course, on digital illiteracy, that also applies to us as insolvency practitioners. Most of us shy away from utilizing the digital resources that are available to us, and in doing so, we are ridding ourselves of knowledge that we could learn just from interacting with these platforms. Someone comes and they're trying to explain to you a contract that was concluded on Jumia, and you don't know the point at which an offer was made. You do not know whether the offer was an invitation to, you don't know whether it's an offer or an invitation to treat. You don't know at what point do we say that property in the goods has passed, such things. So the digital illiteracy doesn't only affect the ecosystem, the entrepreneurs in the ecosystem, but is also relevant to us as insolvency practitioners. We should be able to interact with these websites, to interact with these platforms, for us to be able to understand what is being explained to us by our clients, and also for us to be able to classify a creditor. For example, if you do not know the point at which property passed, it becomes very difficult for you to know whether you're dealing with a creditor or a person who would have been a creditor. So digital illiteracy is a major hurdle. Governance and legal uncertainty, those ones are quite clear, but digital illiteracy is one that is within our control and one that we can mitigate. Like I said earlier, where there's a will, there's a way. Where there's a challenge, there's an opportunity. So we have an opportunity to really champion the cause for a better structure within the digital ecosystem. For example, advocating for the use of e-tools, the use of e-tools to enhance efficiency, transparency, and accessibility, even within the insolvency proceedings. And the result of this would be to ensure streamlined and cost-effective processes. We are heavily utilizing ECMIS, and I think that is one of the tools that gives you a hint on what is possible, especially in as far as the cost-effective processes of the proceedings are concerned. I did mention the potential. Remember, we talked about the cross-border characteristic of these platforms, of these digital businesses, and there is a potential, there is an opportunity for regional harmonization. Like I mentioned earlier, not all countries, for example, within Africa and also within AFTA, have harmonized their laws on cross-border insolvency by bringing them into compliance with the ancestral model law on cross-border insolvency and practice. But there is an opportunity. There's an opportunity for us to push the agenda of economic integration, because at the end of it all, we are creating an environment that is attractive to investors, one that provides certainty, and so on. I must mention at this point that one of the principles of a sound insolvency regime is certainty, predictability, especially for creditors. So when you have regional harmonization, when a creditor in Nigeria or when an investor in Nigeria is investing in Uganda, and for example, they see that Uganda and Nigeria have both adopted the ancestral model law, and that model law has also been adapted for purposes of digital businesses, it is easier for them to know that in the event that things do not work out, which is a risk for investment, this is how I will be treated, or this is what will happen. So regional harmonization is important in as far as harnessing the potential is concerned, and also financial inclusion, which extends economic benefit to the underserved population, supporting sustainable and inclusive growth of Uganda. Again, these are things that we can pursue through the Uganda Association of Insolvency Practitioners. Everything I'm discussing is what can be converted into a code and an agenda for the association. So it is time to wake that sleeping giant. So I think this is the moment that many of us have been waiting for. At the recent insolvency conference convened by URSB, Mr. Silva Kayondo, one of the insolvency practitioners, told me that I shouldn't just come and lecture, but I should at least present some opportunities and key skills for insolvency practitioners. So his prayer has been answered in this presentation. I have a few key skills for the digital age insolvency practitioner, and I will begin with technical proficiency and digital literacy. I often find myself interacting with a number of my peers, and we have different discussions on how they would handle hypothetical situations, on how they would handle a business rescue within the digital space. And we are looking, these discussions come against the backdrop of a slow realization that the traditional model of doing business is slowly but surely being phased out. And what did we mean by that? You find that even the traditional models are integrating their core systems through, for example, the enterprise resource planners. You have different modules of the business coming together, being integrated into one platform or one planner, and they are no longer, labor intensive. Everything is now being controlled digitally, and now you have been appointed as an insolvency practitioner, and you find an ERP. You don't know how it interacts. You don't know how the different modules of the ERP interact with one another and things like that. So it becomes important that as insolvency practitioners, we develop a technical proficiency in things like blockchain, in things like AI, especially generative AI, things like cloud computing, and all these are essential for understanding the core of digital businesses and enabling effective asset tracing. You can't find that which you don't know. If someone is looking for shoes to buy in town and they are in the market and they don't know that shoes are not sold in the market, it becomes a bit of a problem. So you must have the skills to actually do the job. So proficiency is important. That is understanding the emerging technologies. The second skill that is critical is the data analytics skills. I think this has been sung over and over again. And the reason for this is that for you to be able to assess the financial health of some of these companies, you'll find that they are using systems that aggregate all this information into something like a dashboard. So for example, they have the financials of the past 3 years and you're trying to assess whether the company is in distress or whether it's actually in an insolvent state. But in order for you to be able to appreciate the data, in order for you to be able to read into that data to identify that there is a trigger here, you'll need the experience in data analysis. And then of course, technology acumen, having the right aptitude to quickly adopt new technologies. Essentially, do not shy away from the new technologies that are coming on board. Of course, there is a lot of bias. I know there is a bias on the adoption of things like ChatGPT, Perplexity AI, Grok 3, and things like that. But it is inevitable. What you are managing is powered by ChatGPT, and you do not know how to deal with such a situation. So, of course, still in line with the skills that we need to develop, we have the legal and regulatory acumen, developing competences in cybersecurity and data privacy. As insolvency practitioners, the bare minimum is to be aware of the cybersecurity risks and data privacy regulations. It is vital to protecting assets and ensuring compliance. Secondly, of course, still within legal and regulatory, I've talked about the cross-border navigation. We should have experience in cross-border insolvency law and how it works and the international regulations that govern that field. This is important because we are increasingly finding ourselves as part, in fact, we have been part of a global village for a very long time, and digitization only makes that globalization far more accelerated than I think some of us are ready for. Then of course, lastly is legal drafting and documentation. Most of the digital enterprises that we are dealing with no longer host applications or no longer host data on their physical documents, on their servers or things like that, and they're using cloud-based services. Contracts such as the software as a service are going to be seen a lot in our practice. So again, you've taken over a company, software as a service is a contract that has been brought to you for you to confirm whether the asset mentioned therein is an asset of the company or belongs to the cloud provider. And you can't answer that question. So it's very important that we also build our competences along the legal and regulatory acumen. And then again, the most appreciated are the soft skills and the strategic thinking. Like I said earlier, we will not wait, or we cannot wait for the Insolvency Act to continuously modify, because the law will continue changing. There will be another innovation in the future that will necessitate a change of the law. But where we have room to think, where we have room to adapt, where we have room to come up with novel ideas, novel solutions, this is where we fall. We should take that opportunity. So in as far as the soft skills are concerned, stakeholder management is key, negotiation and mediation is key, and ethical judgment is very important. Maintaining ethical standards in digital insolvencies is very critical. And why is that the case? Because trust is part of the superstructure of a digital business. The moment trust is lost, that digital business will tumble faster than it can imagine. So ethical judgment in the management of distress or in the management of insolvency of a digital business is a skill that we must own. And then of course, continuous learning and adaptability. We need to take it upon ourselves to stay current. We need to take it upon ourselves to network and collaborate. Let's not look at ourselves as the end, but let's look at ourselves as the means to a much desirable end. As insolvency practitioners, we have the skills, but we do not have we do not know it all when it comes to things like software development. We do not know it all when it comes to things like infrastructure management and stuff like that. So we need to collaborate with industry experts, we need to collaborate with academics, and we need to share knowledge within the profession. So, attending conferences like this is important. And of course, all this can be made possible not only from each of us taking a proactive role in teaching ourselves, but also for the Uganda Association of Insolvency Practitioners to wake up and pick up the mantle to ensure that we pursue these skills. And there are quite a number of entities that are providing continuous learning in as far as these skills are concerned. So as I conclude, I'll just quickly go through the recommendations and conclusions. Most of these really come out of what we have already discussed: updates to the law, capacity building within the profession, and promoting partnerships. And one thing that I must mention about these key actions is, we are looking at digital businesses. We've looked at what the ecosystem is about, but at the end of the day, we are the advisors. As I earlier mentioned, we are the custodians to the practice. We are the custodians to the entire code and how the code works, the insolvency code, not the software code. So because that is who we are, our clients are depending on us to promote sustainability within their businesses. If it's a digital business, there is something you're seeing that can be done on a certain platform, there is a way the code can be protected and things like that. As insolvency practitioners, as business rescue specialists and the like, it is on us to take it upon ourselves to build capacity. Let us work together. Let's promote partnerships. Let's share knowledge. And let's embrace change. Let's embrace change. In embracing change, there are 3 key things that we need to appreciate. Remember, at the top of the pyramid was the stakeholder management. So we must develop our leadership skills when it comes to stakeholders. You may be able to manage a stakeholder, but your leadership skills are going to come out in times of a crisis. So on the journey to embracing this change, on the journey to adapting and moving away from the more traditional business model and appreciating the digital era that we are in, we need to enhance our stakeholder leadership skills, because this is where a successful business rescue measure will be found. If your business rescue is to be successful, you can't do it without proper stakeholder leadership. We've talked about the inclusive reforms. They should be tech-driven, they should be practical to ensure the continued growth and resilience within Uganda's digital economy, and particularly the digital businesses. And lastly, of course, tech-driven solutions. We are now moving away from file a suit, apply for an injunction. We are now moving to tech-driven solutions, providing solutions that optimize efficiency and equity in insolvency processes, thereby driving sustainable economic development, growth, and innovation. Again, the Uganda Association of Insolvency Practitioners can take up this mantle. And with that, I bring my presentation to a close. Thank you.
All right, thank you so much for that wonderful presentation, Paul, on insolvency in the digital economy. We really had so much to learn about, looked at the opportunities and the potential. Thank you so much for that. At this juncture, would like to take up any questions that are there from our online audience. In case you have a question, you can just raise up your hand and we'll pick you and you can ask your question. Any question? Okay, if there is no question, let me get back to our physical audience here. Do we have any question in here? Okay, if there is no question, are there any questions? That means either the presenter was very good and there was nothing left untouched, unturned. So I want to thank you so much, Paul, for that brilliant discussion. And I believe it's 12:30, 12:32. So okay, yes. So right now there is a poll that is running on your screen. Please would kindly request you to fill in that answer, the poll, the survey, because this will help us to know which areas to improve on, what to do better, you know, to self-evaluate ourselves as well. So please let's give in that feedback. And in the afternoon we are having a panel on tax and insolvency, and we have a lineup of exceptional speakers. We have Mr. Isaac Mugera from Bluebell Legal Advocates. We have Mr. Nelson Nerima. We have many speakers lined up, so please ensure you don't miss. We're going to be starting at 2 p.m. sharp. We also have Rita Virunji from Legomac Advocates, and yeah, it's going to be wonderful. So let's ensure we're there. Yes. So allow me to call this session to a close. In case there are no questions, we shall resume at 2 p.m. on the dot. Please stay locked in. Please don't go away. Thank you so much.
A very good afternoon, ladies and gentlemen. My name is Rita Aguma Birunji. I'm an advocate and an insolvency practitioner working with Legal Mark Advocates. I would like to welcome you all to the second session and the last one for today. I am here to play the role of a moderator for a very interesting topic on insolvency and taxation. And I have a panel of very distinguished gentlemen and a lady that are from diverse offices within our spaces that I'm going to introduce very briefly, and then we'll go straight into our conversation. The gentleman to my immediate left, Mr. Nelson Nerima, a distinguished lawyer, the managing partner of Nambala Nerima Advocates, an insolvency practitioner, my former teacher. It's an honor to have you on this panel today. Immediately following Mr. Nerima is Mr. Tony Kalunji, a very familiar face in this conference, and I believe who needs no further introductions because Tony was with us yesterday and gave us very thorough insights in his perspective that we're going to dig a little bit deeper into, but from a different perspective today. Thank you, Tony, for coming. We also have Mrs. Rachel Nirinjie, a senior officer with the Uganda Registration Services Bureau in the Department of Insolvency, in the Directorate of Insolvency. Rachel is also a very familiar face in the insol space. Rachel, you are very, very welcome. And finally, we have Mr. Isaac Mogera, who is the managing partner of Bluebell Advocates. Mr. Mogera is also a seasoned lawyer and an insolvency practitioner who has been involved in a number of a few decisions that we've discussed from time to time. So our conversation for today is really the stretch of the relationship between tax enforcement and insolvency, really looking at more importantly the growing intersection between the two practices. And I do know that yesterday we had a conversation on URA's involvement as a government agency, but today we want to look at more specifically how we've seen in the recent times a growing friction between tax enforcement and insolvency proceedings. And I would like to go straight into our conversation, starting with Mr. Nerima immediately to my left. The question is, in your experience, and Mr. Nerima, you are an advisor for insolvency practitioners. You've advised creditors, you've advised debtors. So you've been in the thick of things, and you're also an insolvency practitioner. In your perspective, what is the biggest challenge that you face in when these two regimes, insolvency and tax enforcement, when they intersect? What are the challenges that you face?
Yes, thank you very much, Rita, for your kind introduction and for moderating this discussion. Yes, intersection between insolvency and tax. I think the biggest challenge is about conceptualization of what insolvency is about and what it is meant to achieve. We all know that in insolvency we are seeking collective satisfaction of claims, but it's not yet appreciated, especially in this jurisdiction. People are still in their respective silos. For you, the insolvency practitioner, in your mind, you are thinking about collective satisfaction of claims or debts. but the taxman is looking at insolvency as a way of recovering his or her taxes. The employees are thinking about their remuneration. NSSF is thinking about social security contributions. The bank is thinking about its mortgage. So everybody is pulling to ensure that the proceedings are used merely as a tool of debt collection. So I think that is the biggest challenge we still have, that insolvency is not like a summary suit or a plaint which you file to recover your money as a particular creditor, but it is collective. So I think that is the biggest challenge, and that is why we even have this friction of talking about taxes in particular. Then tomorrow, someone will say, no, employee claims are actually the most important. Before you think about anything, think about the employees. So we need a mind shift, a mindset shift, so that we can all appreciate that insolvency proceedings are primarily for collective satisfaction of claims according to insolvency law. Even if, be it taxes, be it salaries, be it ground rent, it should be collective satisfaction. In insolvency, we look at the priority, and there are no sins which are greater than others. All sins are equal. In insolvency, it is collective satisfaction, and we try to ensure that everybody is treated equitably. So for me, as a practitioner, that's the challenge. Failure to conceptualize the object of insolvency, and stakeholders tending to think that it's about them, yet it's about collective effort. Thank you so much.
Thank you so much, Mr. Nerima, and I hope that we all don't, the rest of the panelists have different views, and I'm very interested in hearing from Mr. Kalonji, particularly because yours is an enforcement job which is statutory. So when you face an insolvency situation and you meet Mr. Nerima, who's saying insolvency is a collective tool, yet you have a statutory obligation to collect, how then do you appreciate the situation in your perspective?
Thank you, Rita. I agree with Mr. Nerima, just that I might use different examples to paint my perspective. And let me use a specific one. We had the case of Bank of India versus URA. By originating summons, a bank filed a suit seeking questions to be interpreted by the High Court Commercial Division on whether, as far as their debts crystallized, URA could also continue enforcing. And the first challenge we noted as URA from that decision was the difference or priority between laws of Uganda. On one hand, URA was holding on to the Tax Procedure Code Act and tax laws, saying, one, the High Court does not have jurisdiction, it is a tax matter. Secondly, even if it is a tax matter, even if it is not a tax matter, the tax liability came earlier. And then on the other hand, Mr. Nerima managed to successfully argue that no, it was not a tax matter, in as far as it was originating summons and so much, and the judge agreed with him and made a decision. But you could see the interplay between sections of the law, and when we, for instance, used that same decision, we had another dispute in the Tax Appeals Tribunal, and we said, according to the High Court precedent, the Tax Procedure Code Act is not a taxing act. Therefore, this matter filed by an informer for failing to pay him the top-up on the amount of money he claims is supposed to go to the commercial court. You would find a tribunal, though lower, respectively saying that decision was made by Incurium. And then there are articles to that effect. So the priority between the laws is not limited to Uganda. There's jurisprudence all over where there is a debate on conflicts of which law takes precedence, whether the taxing laws or the insolvency laws. And from our perspective, it also conceptualization. If we sat together on the same table and stopped working in silos, maybe we could agree. But it's just that there are different approaches. There is hot and cold. I don't know whether it's even possible to agree, because in our view, you find when it comes to insolvency, the bankers will front the law. They say, once I'm secured, it's floating, now it is fixed. By therefore, I go in the Insolvency Act, I'm a receiver. The taxman will front the taxing law. Employers will say, I'm entitled to my wages, and therefore under the Employment Act, you're breaching it. I'll probably do that. NSSF will come with the law. So the interplay between laws when insolvency comes up is what is the major thing I see. And the priority list, the priority that is in our Insolvency Act, the 11 and 12, I don't know whether at the point of agreeing to that, all stakeholders were on board, because it seems some didn't agree to that approach. Otherwise, if we incorporated it in our respective laws, we would agree, because it can't be, and I said it yesterday, that the Tax Procedure Code Act says that the Tax Procedure Code Act is a supreme law when it comes to any other law in Uganda. Also, the Insolvency Act says that the Insolvency Act takes precedence over other laws. You have the East African Community Customs Management Act that says that the East African Customs Management Community Act is a superior law when it comes to all laws in Uganda. All laws are claiming superiority, but we have to apply them, and we see. So we hope to get either clarity from the stakeholders, such as Parliament, or the court systems to interpret, but it's a revolving debate.
Okay. Thank you so much, Tony. And I'll move on straight to the one of the policymakers, those who must have contributed to the law that we are now talking about. Rachel, in your position and being part of the framers of the law, what are the challenges that you see when you have an intersection between these two regimes, and more pointing towards the cases that Tony just highlighted and a few others that we may not talk about here, but there are quite a number that have been coming up, and somehow you're also in the middle of it. Could you share with us your experience as a regulator of insolvency practice?
Thank you, Rita. I think I will add my voice to Mr. Nerima's submission that what is the intention for insolvency proceedings in the first place. Sorry. The intention is mostly to preserve the estate for the benefit of the general body of creditors. And the general body of creditors includes the moment a company goes into insolvency proceedings. The general body includes the taxman as well. And then we go to the issue of priority and all that. So on the issue of tax and how it can be handled during insolvency proceedings, when the insolvency practitioner is appointed, they have a duty upon them. Actually, I think under the Income Tax Act, they have a duty to notify URA and ask URA if they have any claim against that particular company, and then the URA should be able to lodge their claim. And if an insolvency practitioner does not do that, then they are held liable under the law. So there's been a way in which the law has tried to create a correlation between the Income Tax Act and the Insolvency Act to put the taxman on notice when a company goes into insolvency proceedings to find a way of harmonizing. I will agree that sometimes we've had a standoff on whether tax should be given priority of insolvency proceedings. But I think if we address the issue of what is the intention for insolvency proceedings, that should be able to answer all the subsequent questions and issues that arise. It is for the general body of the creditors. And then once you understand that it's for the general body of the creditors, then you go to the issue of priority, who comes first, and what are the percentages that are applied.
Thank you, Rachel. And picking up from there, you mentioned a standoff that we see from time to time. I would like to ask Mr. Mugera, when as a insolvency practitioner, from your experience, do you see scenarios where, in the present framework as it is, with the silos and the limited understanding or conceptualization, have you seen situations where it's possible to mitigate the tension, and how is that done? Speaking to a professional or someone handling an insolvency matter out there, and they have this crisis on their hands, is it possible to minimize this tension and be able to balance the tax enforcement alongside a creditor benefit? The other creditors, because even you are as a creditor, so the other creditors, the benefit to them.
Thank you. Thank you very much, Rita, for that question. I believe, firstly, adding to what the rest of the panelists have said, that over and above the challenges we face during the proceedings, I think it's also important to appreciate the challenges as a result of, personally, I believe the irregular enforcement by the tax authority, by URA, that preempts the mode of insolvency proceedings sometimes. And we talk about business rescue mechanisms as well, that insolvency proceedings that could have taken a mode of voluntary winding up are forced to take a creditor's voluntary winding up, or if it would have been provisional administration, receivership, or whatever it is, the creditor's voluntary winding up is forced as a result of irregular tax enforcement. And for me, before I get to that question that you have asked, I believe the irregular tax enforcement, including, for example, this 30% that is required to be paid, could make entities change their strategic plan. We have one that we've handled where an entity that would probably continue, having its business being a going concern, decides to pull out because the shareholders are afraid of the reputational risk that will come out of continuing to do business in Uganda, especially when an adverse sum has been asked for URA to be paid. It's too high. It probably could be paid, but the entity is thinking, why continue in business anymore? Now, because it doesn't want to go through the processes of objection, it straight away abandons doing business and gets into a creditor's voluntary winding up. Could have been voluntary maybe, but because of these adverse claims that sometimes start when the tax authority foresees the possibility of a winding up. Now, your question on, and then this also goes to aspects like certain creditors have been given or not given, are more powerful than others, in spite of the existence of the law. You would notice, for example, that if you go to the Tax Appeals Tribunal, the registrar is unable to grant an interim order of injunction that allows, that includes the fact that the payment of the 30% should be deferred. Now, the law allows injunctions to be given. For example, if the issue is whether payments should be made, the registrar will say, I have no powers to make orders that include the deferral of the payment of the 30%. Now, you would cite cases, but nevertheless, that order will not be given by a registrar. But remember, the company, perhaps if it was 30 billion shillings, ought to have paid 30%. And naturally, the company would, the course of liquidation would be determined by that inability to pay the 30%, and it's been locked out of the legal process. But to answer your question in respect to how do you address, as a professional, in my opinion, the rules are more or less clear on what needs to be done. Priority creditors have been mentioned. Processes are very clear in the Insolvency Act. And once the practitioner follows those rules in terms of the investigations that have to be made in respect to defaults, in respect to how to handle the different stakeholders, I think all would be settled.
Thank you, Isaac. And picking up from just where you talked about what I picked to be a tax planning and probably challenge in light of that could lead to an insolvency situation, I would like to ask you, Mr. Nerima, as an advisor to some insolvency practitioners and as a practitioner and as an advisor to creditors, do you think there is a line, especially in an insolvency perspective, between efficient tax planning and there's a thin line between efficient tax planning and tax avoidance, to the extent that in some cases planning can be considered, efficient planning can be considered avoidance?
Thank you, Rita. As I said at the beginning, insolvency gives you a fresh start. It's like being born again. That all sins will be forgiven or washed away. And if we understand the objective of insolvency, then we would not be very eager to categorize that this one is trying to avoid paying taxes, this one is trying to avoid paying workers' salary arrears, this one is trying to avoid paying rent to his landlord. Once we understand that it is for collective satisfaction, whether they are taxes, whether they are what. And in my view, my personal professional view, is that if you feel that you are unable to pay your taxes, not refusing, but because there is a difference between inability and refusal, or neglect, or unwillingness. The law uses the word inability. So if I am unable to pay my taxes, then under the law, I have a genuine ground to seek an insolvency remedy. Someone may argue that insolvency is a method of aggressive tax planning, and so be it, because the law allows it. The law does not say that those who have failed to pay taxes should not benefit from bankruptcy protection. The law gives blanket cover to anyone who swears that he or she is unable to pay their debts. So in my view, so long as someone can show that they are unable to pay their debts, including taxes, they should be encouraged to seek insolvency remedies so that they can have a fresh start. It is true that once you are declared bankrupt, or if you are a company and you are liquidated, whatever little is realized will be shared. And if you are a human being and you are discharged, you get a fresh start. If a company's assets are liquidated and distributed, the shareholders or directors get a fresh start. But I understand the sensitivity of pursuing insolvency when you are heavily indebted. I think the most sensitive debts are two: taxes and workers. That now you owe your workers salary arrears, and now you are going for insolvency. How will the workers recover? It's very emotional, and there are also sentiments attached. For taxes, it is not sensitive among the general public, but for the taxman, it is extremely sensitive. And I think in realizing and distributing assets, I think the taxman is the least popular among all creditors. I think there is almost no sympathy for taxes, but for the taxman, it's extremely sensitive. So in my view, tax avoidance or aggressive tax planning is not illegal. What is illegal is tax evasion. But even if a company or its directors were involved in tax evasion and now they are insolvent, does it mean that the remedy of insolvency is not applicable to them because they committed tax evasion? Insolvency is civil, it's not criminal. So in my view, for as long as you are unable to pay your debts, you can take advantage of insolvency. If you've committed crimes in the past, then those can be dealt with using the applicable criminal statutes.
Thank you so much, Mr. Nerima. And as you're speaking, I was thinking of, as yourself and Mr. Mugera was speaking, I was seeing the challenges that URA faces, and for a moment there, I felt some sympathy for you, Tony. And for a moment, I'll be honest. And I would like then to inquire from you if internally as an institution, and in light of the challenges we've just discussed and the legal framework as it is, whether URA has some specific policies or internal strategies that you have adopted to be able to collaborate these two regimes. Are there any specific policies we should know about and perhaps take advantage of or prepare for as practitioners and advisors?
Yes, thank you, Rita. Yes, they are. I would say they are there. In the Legal Services and Border Affairs Department, there is a division. Previously, it was called debt collection, but now it's tax arrears management. And the essential role of that division, of course, it might not specifically focus on insolvency, but all debt, all tax that is unpaid and is not in dispute is managed there under. And for so long it has been known, it is actually known that for you to head that department or to work in it at certain levels, you have to be a person who is skilled, not only in tax law, actually even if you're not skilled in tax law, but specifically insolvency. That's why you'll find that its previous leaders of that division, we have now the current Justice of the Commercial Court, Justice Patience. We have now the current, I don't know whether he's still at UCC, Abdul Salam. I recently bought his book on corporate rescue. You find that for him to get that position, he had to convince the board that among all the applicants, he was the only one who had a master's degree in insolvency from Nottingham University. Then you come to even the current one who is there. The people who had that division are actually skilled in insolvency and debt management. Then when you come to the policies, they have designed policies that actually respect insolvency laws. And that might be one of the reasons, now that the case is concluded, that I could inform my colleagues as to why we took time before filing a certain application. Because internally there were internal memos that if a company is under insolvency, let it go. Let that debt be handled under the insolvency regime. And Rita talk about it, you realize that one of your bosses or partners, Mr. Karamaju, was given the insolvency work of WBS. Essentially from the start, if companies are unable to pay, we actually engage insolvency practitioners to help us recover it. So the policies are there and they are reflected in the existence of the division. The people who work in the division have the skills, extreme skills in insolvency. Then there are measures they have developed, and internally it is known that once we are notified that a company is under insolvency, normally we let the insolvency regime take over. The challenge and what causes this friction is transparency, or what I would call the information asymmetry. We normally get to know that a company is undertaking insolvency measures when either at the same time or after the taxman's enforcement mechanisms have already kicked in. For instance, we will not know, and without knowing, we'll also have engaged measures to maybe attach property. But once we know, it is a given, and we let it go. Although I think we might need to take it further and maybe try to specify that whenever a company is under insolvency, either it should be either red flagged, I don't know how we get to know, maybe the regulator, the official receiver, but when we receive that notification, normally we inform people not to go ahead and comply. It acts as a court order. Except, of course, there are cases when we review the same and we need to verify. You'll find, for instance, if we review the application, if someone, let's say, has applied for insolvency under voluntary winding up, we don't just take it as a given. We can analyze the application and say, if really you've applied for voluntary winding up and among the documents there's a resolution saying you'll be able to pay the company's debts within 12 months. There's a statutory declaration from a director that they'll be able to pay that debt within 12 months. And you find that that debt that is listed does not include the taxes that we have on your ledger. There, we might not take it lightly. We might come into challenge. But if everything is as it ought to be, normally the measures are there and we respect the insolvency procedure. Thank you, Rita.
You threw the microphone to URSB to tell us how they can be able to support you in trying to keep tabs with ongoing insolvency proceedings. But before Rachel, you answer, I personally have seen specifically the challenge with tax enforcement is on administrative processes. A clear-cut receivership or liquidation which doesn't have ongoing business seems to be straightforward for URA. But I think the complications come when you have ongoing business, maybe winding up business, or some form of administration that facilitates income generation. Is there any specific framework for management of such situations? It's still an insolvency situation, nonetheless, but there is activity that is showing business rescue as we want to pursue the conversation. Are there particular safeguards you've put in place to protect those businesses?
Yes, they are. Generally, there is no specific guideline that lists all of this, but normally the practice is that we look at a situation and we come through. We have received requests for reorganizations or restructurings or administrations, and we normally approve by entering into either MOUs or agreeing if we are comfortable with the situation. Then there is where we even give people time and we say, in this period URA will not enforce, but you'll be given a period within which to organize yourself and will come through. That the debate could be on how long that period is, but at least we give the period or a breather. So the measures are there, but we have not specifically codified them, although in the pipeline we should expect, depending on how fast the minister signs, there's going to be what they call the debt write-off regulations that will be issued under the Tax Procedure Code Act. Those ones have provisions that cover these. So if the minister passes them, depending on how they come out, we are going to, the scenario is that if someone is not able to pay, they will address the issue of if someone is not able to pay their taxes, how is that tax remitted and you never recover it? How is it written off? Who qualifies for a write-off? What do they need to do to apply? What are the considerations? And so much. So that is intended to specifically cover out tax as a debt when it comes to insolvency, whereby instead of you applying for insolvency, you can simply say, forgive me my tax. And if you qualify, there should be no issue with that.
I can see many of us will apply for that forgiveness. We can't wait to see those rules or guidelines from the minister. And Rachel, back to you on the question of URSB's contribution. One, answering his question on how they can support, on how you can support URA, but also how you as a regulator are supporting insolvency practitioners in dealing with some of these challenges. And it's the practitioners and the companies where you get involved. Do you carry out any investigations to assess how genuine some of these claims are, or before you accept, for example, creditors voluntary winding up? What steps do you take to support URA in assessing some of these positions that are claimed by companies?
Thank you, Rita. Maybe to answer Mr. Kalunji on the issue of supporting URA. One, when insolvency proceedings are initiated, be it voluntary, court, members, creditors, you are required to give public notice in the Gazette and in the newspaper. So the presumption is the taxman should also be able to see some of those public notices that are issued. However, in addition to that, and Mr. Tony will testify, where we have had matters that are controversial, we have taken the extra step of writing to URA and asking them to confirm whether this particular company has a liability with them, and they have always responded. That's one. And then how have we supported insolvency practitioners? Most times, or in some instances, companies will try to utilize the insolvency proceedings to avoid liabilities, or especially in light of the recent amendments, people want to use the short process, the one that doesn't require appointing an insolvency practitioner, and they will come to the official receiver and say the company has no debts, it has no liabilities. So the extra step we've taken as a regulator is to ask them to present tax clearance from URA. And then once you ask for the tax clearance, that's when they will confess that in all honesty, we have a debt. And the moment they confess that they have a debt and they can't get the tax clearance, we ask them to appoint a liquidator instead of going through the short process, so that the liquidator can be able to interrogate the affairs of the company and also be able to notify and put on notice all the creditors that the company has. So that's the extra step that the official receiver has taken to support URA and also the insolvency practitioners. But when we receive insolvency proceedings, even when we are notified by court, we don't take it on face value. We go ahead and interrogate the company file. If you tell us, when I registered the company, I was looking for funding, I didn't take off, I have no debts, I have no liabilities, I'm kindly requesting to be removed from the register. And then when we look at your company file, you have share transfers, you've opened bank accounts. Clearly, there's been transactions happening in that company. So there is no way we are going to allow you to just proceed without one, putting the public on notice, or engaging the creditors, or engaging the banks and any other person who might have a debt or a transaction with this company. So we go beyond the paperwork that is presented to us. We interrogate it, and we usually advise the client and the insolvency practitioners on the way forward. Yeah.
Thank you. Thank you so much, Team URSP. Mr. Mugera, as a practitioner who we find ourselves advising these clients even pre-insolvency and pre-commencement and then through the appointment, what do you think should be the extent of your involvement as a practitioner to limit your liability in cases like the ones URSB is talking about, where we misrepresent that we have no debts until they ask us for a tax clearance certificate? So how do you advise other practitioners to deal with such situations to limit our liability and what they would call collusion?
Thank you, Rita. Since I go last, I pick up there are certain burning responses that and one of them is Mr. Nerima talked about somebody being forgiven of their sins, as part of the insolvency process. And I actually wanted to add that the insolvency laws, the act itself, has maintained certain sins. And even when the sins exist, it has specified which of those sins should be punished. For example, if you look between section 15 to 18, it talks of suspicious transactions, voidable transactions, limits periods, some at 24 months, some at 12 months. I picked up interest because on that discussion from Nelson, because the creditors, including the priority creditors, the preferential creditors, have an opportunity to still pursue the insolvent for those crimes. And if those crimes, if it's outside the ambit of those crimes, then the insolvent should be allowed to go through the process and have a clean start. Now, back to your question, I believe an insolvency practitioner's role starts many times before sometimes during the advisory stage leading to the commencement of insolvency proceedings. So my advice would be, and I pick from a recent case that we handled, where I was grateful to have handled the process well, because if it hadn't been handled well, you can imagine the backlash that would come during the court proceedings. So before proceedings, before the insolvency is commenced, it's important to advise the client on first doing a legal audit, to advise on compliance issues, existing compliance issues, a finance audit, to confirm that certain aspects, to determine that the liabilities are liabilities and the assets are assets. And based on that advice, then to consider the available business rescue mechanisms, and then to determine the mode of insolvency. If it is a voluntary winding up process, then you would be a member's voluntary winding up. You would be in order to continue with the client, and I would advise that if it's a creditor's voluntary winding up, then you would be conflicted to continue with it, since you have been advising the client on aspects to do with the commencement of the liquidation. In my opinion, you would be conflicted, and it would be a very good opportunity at that time to advise them to pick from a number of other insolvency practitioners, and perhaps to stay on in the process as an advisor to ensure that the preliminary aspects of commencement of winding up are followed. If you are the liquidator within the insolvency, the liquidation process, I think it would be very important to ensure that you appreciate your roles as a liquidator, including the investigation, as I have mentioned, under section 15 or 14 to 18 of the Insolvency Act, and to actually undertake that investigation seriously, because remember, as a liquidator, your role is not limited to the shareholders or directors that have initiated your appointment, and it's not to the creditors that could have appointed you. It's not only to them, but it is to the owners of the business, to the creditors, and all of these want their value to be maximized. So if you appreciate the fact that you need to be an independent investigator, and I also advise that if you do not and you cannot have the expertise as a liquidator to undertake the investigative roles, companies are different. For example, an investigation into the intangible wealth, for example, from intellectual property, may need to be undertaken by an expert in that field. A police investigation related to suspicious activity from the directors, including collecting evidence, for example, from bank statements and, cross-border transactions. Perhaps you may need Interpol or you may need a private investigator. Some entities are quite complex in terms of their finances, that the financial information that is given to you, in spite of your training in taxation at a law development center, you may be limited in appreciating tax matters. So you would be in order as a liquidator to hire experts to look into complex financial matters, evaluation of projects. You may not be in position to value property as a lawyer, in spite of the values that have been put on. Is my time running out? Yes. So ideally, getting all these experts is very important in order to facilitate a proper and to limit liability that may accrue to the individual, to the liquidator. Thank you very much.
I would like to follow that up with a question to Mr. Nerima, and I'll come to you, Tony, as well, on how the things that Mr. Mugera has talked about would then feed into the cost and time of an already bleeding establishment, if you have any views on that.
Yes, thank you. I also actually thought about the cost when I had my colleague talking about getting professional expertise to investigate or to advise. Ideally, it would be good for an insolvency practitioner to get expert support to advise, to investigate, to report, and so on. But as you've mentioned, many times the challenge is it's very expensive. The reason why you've been appointed as a receiver or a trustee in bankruptcy or a liquidator is because the debtor is insolvent. They are unable to pay their debts, and when you get in, you'll find that there is not enough money to hire legal mark advocates to provide a legal opinion, or to hire an accountancy firm to conduct a tax audit or to advise on tax. Much as ideally it's recommended that you do that, but it's true that most times the resources are not available. Fortunately, insolvency practice has been professionalized. Not anyone can be an insolvency practitioner. When I started practice, a court bailiff who holds a P7 certificate but is licensed as a bailiff could be appointed a receiver. Not so? Yes, so long as he has kanyamaz and contacts, but and in the police and elsewhere. But that has now ended. All insolvency practitioners are professionals. You are either a lawyer or an accountant. And it is envisaged that before you became an insolvency practitioner, you received training in your respective profession. So I would expect that anyone who is a lawyer worth his or her salt would have some basic knowledge and competence in matters to do with tax and the law generally. Similarly, I would expect that an accountant who has been registered as an insolvency practitioner has basic knowledge about accounting and tax, that he can look at the records and the transactions and advise as to whether this client is insolvent, as to whether there are fraudulent or voidable transactions, and so on. So the bottom line is that we as insolvency practitioners are expected to abide by a code. And I think our practitioners' regulations contain a code of conduct. Is Schedule 2? Yes, Schedule 2. We have to conduct ourselves professionally, accurately, truthfully, and in an unbiased manner. So much as sometimes you may require outside help or expertise, but we are expected that by virtue of being insolvency practitioners, we are able to handle the work which comes to us with professionalism. And that is how you protect yourself. That for me, I acted professionally. I looked at the records, and this is what I found. So long as you've conducted yourself professionally, I think you would be protected. Someone might disagree with you, but so long as you acted professionally.
Thank you. Thank you so much. And we are coming to the end of our session. I would like to request you, Tony, to give us some insights into whether there are any red flags, some general red flags a practitioner or a legal advisor to an insolvent company can look at, the things that you can see and say, this one on the face of it is trying to avoid or evade taxes. All of this process is really a process to cheat the taxman, so that we can also approach it from a point of your position, how you would look at it. Are there any general red flags that you tend to look at?
Thank you, Rita. The first one is abuse of the law. Now, abuse of the law is general, it's not limited to tax, and we can even look at other laws that are involved. Let's say in particular now the Insolvency Act. And we look at it in two aspects. You can abuse the law literally. Let's say, as you talked about it, you're supposed to notify your creditors, such as URA, and you don't notify your creditors. Whereas there's that avenue of a gazette or a public notice. Ideally, if one of your creditors is URA and we are not notified, literally there is something you have not properly done. So there we'll take it as a red flag that may be the reason for not notifying URA and us getting to know out there is because it's a red flag, and we use it to question and verify. Now there is also another form of abuse which is not literal, but it's abusing the intention of the law. And this is where I think the controversy comes from. You can do everything properly, but when we just realize that you are abusing the intention of the law, in my view, and this is where I think the thin line between me and other people like Mr. Nerima almost narrows down. Someone can boldly say that that one who fails to pay taxes can boldly say that they are going to go and use the Insolvency Act. Now, from an insolvency perspective, I understand that's okay, but from the tax angle, whereas ideally there is no law prohibit, there is nothing penalizing you from failure to pay tax, but when you take any action, especially even if it's voluntary and you try to avoid tax, the current regime world over is to consider it as an abuse. Now, for instance, let's say, and Mr. Mugara raised an issue, let's say because you cannot afford 30% of the tax in dispute, you decide that let me opt to file an application under the Insolvency Act. From the taxman's view, that looks up, it's a red flag on it, the way you look at it, because there are avenues if you fail to pay 30% that you can come up to. You can choose to resolve that dispute under a DR where you can't pay 30%, you can ask for installment payment, you can ask for a waiver, but without undertaking those mechanisms, you're like, let me go to insolvency. It becomes a red flag at that point. Then there is also when you consider the entire transaction, and I'll give the example of that case of Bank of India. Insolvency can be a tool for tax evasion, and Mr. Nerima hinted on it. Because if I'm running a business, all I have to do is go and borrow from the bank, and I get I finance my company with debt. When I get that debt, as I generate income, instead of paying my creditors, if I have 3 creditors, instead of paying the secured one, the bank, and I pay taxes and I pay the workers or NSSF, I can decide within a period to manage the company by either not taking dividends but taking a lot of management fees, taking a lot of expenses, and if I'm remain with that money, if I remain with a few, I can choose to either inform the secured creditor that have failed to pay and they initiate insolvency proceedings. If they are secured, they will only take that and URA will move out. I can also file on my own and I kick out URA. So from a taxman's perspective, insolvency can be designed in a way not to pay taxes. So the intention, we look at the transaction and we see the purpose of why you're doing this. For instance, URA cannot give you an assessment today. After it has given you an assessment, whereas you can argue it indicates that you owe the liability. And when you're in the process of objecting, and after it has made an objection decision, you choose to go under insolvency. Our view is that and our definition of abuse of the law is if you use the law for a purpose within which it was not intended to. Our view is that the Insolvency Act was intended to provide relief to people who are unable to pay their debts. Now, if you make it blindly that it was intended to be a refuge for those who are unable, sometimes we even realize or unwilling to pay their taxes, then it becomes an issue. Because for you to get an assessment of, let's say, 30 billion, if you're a company that is only 30% of your gross profits, it means that the records we have in URA show that the amount of money you have is 30 billion. It is only 30%, so you will need to multiply it by 0.7. So it means at least the money that has passed through from our side, you almost have over 100 billion. We're only demanding 30 after the profits. Our view is that that is not a person who is unable to pay their debts. You have had the money. And then if we look at your finances or your audited books of account, it can't be that before you run into a situation of not being able to pay your debts, the salaries you were paying yourself, if we compare people handling similar transactions in a similar network, they were of such a level that they are high. The costs you are using to run this franchise were high. You own all these assets. So the way we look at it as abuse, it's a red flag and we normally investigate you. The second one is substance over form. You can front the simplistic view that maybe you're going for voluntary winding up, but when ideally you're forcing an involuntary winding up, because were you able to pay your debts, you would have paid taxes. So I wouldn't expect anyone with a tax liability to file for a voluntary winding up. Why? You'd rather at least pay it and continue, if especially URA is your only creditor. You need not go through the process. Then we have a legal versus economic substance, whereby at the end of it, legally you've structured it well and it is okay. We can't find you anywhere, but the transaction does not make sense. And where does this come up? We will have taxpayers who, you know, that section that those voidable transactions, if transactions have happened can be set aside if they have happened between either 6 months and 12 months prior. What most taxpayers do, and it's not unusual, if you go to URSB and you carry out a search, you will see that it's either asset stripping or it's a vigorous shareholding change that has happened. And then when you look at it legally, that's allowed. You're allowed to sell your shares. You are allowed to sell your assets. But it can't be that from the point of the assessment and from the point when you file for insolvency, you've structured your transaction in a way that in between there, the period is beyond the 12 months for us to make it voidable, but it's not before the assessment. It could be that economically you're trying to make people exit the company and leave it as a shelf for there not to be any collection. So that's also a red flag. And then you'll get sham transactions whereby a person has been transacting in a company, they have been making losses, but when you look at how the losses have come about, you question whether it was necessary for those losses to exist. You can have transactions, and this normally happens in group enterprises, where you find that the company in Uganda is not making any profits, yet it's the one generating most of the income. And when you ask them, they will tell you, this business that we are running, the intellectual property bit of it is owned by our holding company, which you have to pay royalties. Or the work we do when we get contracts needs expertise from another company we are related to, which charges us heavily. And you ask yourself, why would someone who sets up to make profits continue in a business voluntarily for this period if they are not getting anything? So it becomes a red flag on our side. Then also, what we look at, and this is mainly in the law, if you look at our Income Tax Act, we have powers to rearrange transactions. You look at it and you're like, whereas and that power to rearrange transactions with due respect to insolvency does not limit us to, does not say except for insolvency proceedings. So our view is that if a transaction appears not to make economic sense, appears to be devoid of substance, or has one of its principal purposes to be avoiding tax, the powers are given to the Commissioner General to rearrange it. And for that, so when we look at those red flags, we normally, we don't per se decide, but we investigate further and we try to see. But in summary, it's just abuse of the law. It can be sensed. Someone who is genuine, we can know. And I'll keep giving the example of, let's say, WBS, who will come in and we are like, let us assist. There are those taxpayers who genuinely can't pay. But there are those who you look at and you wonder and you're like, if you've been profitable for all this long, out of the blue you're leaving, what could it be? So those are the red flags we look at.
Thank you. That was a sneak peek into the mind of URA and insolvency cases, and many of the points were reaction provoking. I can imagine my colleagues here, and I'm going to request that each one of us gives in a minute your closing remarks. We'll see if we have any comments from the audience, maybe the members in the room, if anyone has a comment. But before that, let me request my colleagues to give their closing remarks. You could respond to Tony, or we can take it offline. I'm going to start. I'm going to start with Mr. Nerima and move towards Isaac so that we can close. Thank you.
Okay, thank you very much, Rita. My closing remark will be to urge that our taxman should be proactive and not reactive. Because when the taxman is reactive, he spoils the party. The party is insolvency, collective realization, So when the taxman comes late to the party and spoils it, it's not good. He takes us back. So they should be proactive. They have remedies. Mr. Kalonji talked about information asymmetry, which I don't actually agree with, because as Rachel said, the law provides for public notices, filing with the official receiver, which are public records. The law allows the taxman to file a charge on an asset. Not so. You can file a charge on an asset. In the company registry, you put a charge on the shares. In the land office, you put a caveat on the land and you become a secured creditor. So we would urge our friends to be proactive and not reactive. You make sure you protect your claim as a taxman way in advance. Otherwise, if you come late to the party, it will become increasingly difficult for you to undo or reverse. You'll agree with me, Rita, when you were still a student, how many bankruptcy or winding up cases were in the court system or when you were starting practice? Very few, extremely. But now, every year, the number of bankruptcy cases is increasing, winding up petitions, voluntary liquidation. Every year, they are increasing. I don't know if URA has the capacity to oppose the hundreds of bankruptcy petitions, provision administration, winding up, requests to be struck off the register. There are so many. And I don't think the current approach is sustainable to appear and oppose, to say, oh, he's not bankrupt. He's solvent. When the cases were few, it was easy. But going forward, I think it will become expensive and unsustainable. So my advice would be to be proactive, invoke the remedies you have under the law. Actually, apart from putting a charge, you also have power. You have a right to be notified when someone is appointed a receiver, not so? Yes. The insolvency practitioner must inform the Commissioner General. And I think for VAT and stamp duty, if there is a tax liability, I think the Commissioner General can require that the receiver gets permission before disposing of an asset. So instead of fighting with court, why don't you put a caveat, even if a company is under receivership, to say, under the law, my permission is needed. I have a lien. So my bottom line and closing remarks would be to encourage proactivity and non-reactivity so that our party is not spoiled and our party is getting bigger and bigger in insolvency. Actually, very soon some people will be full-time insolvency practitioners. Thank you.
Yes, Team URSB.
Yes, thank you, Rita, and my fellow panelists. I just wanted to comment on Mr. Kalonji's submission about the red flags, and I wanted to reiterate what Mr. Nerima said, that insolvency practitioners are held to a certain code of conduct under the insolvency law, but also the reason one of the requirements for becoming an insolvency practitioner is that you should be subscribed to a certain professional body, is that we expect you to also have a certain code of conduct that you live by in your profession. So once you are appointed an insolvency practitioner, don't start from the point of being appointed, but also interrogate some of the transactions. For example, if there's been asset stripping, if the directors or shareholders have transferred assets to themselves at undervalue, and all those avoidable transactions that can be questioned, you can actually go against them and prosecute them, and also seek for the help of the official receiver in the event that you need support. We are a public office and we are always ready to support. I would like to say I thank ULS for this initiative. that we've been given to talk about insolvency. And like Mr. Nerema has said, insolvency has become quite more popular than it was a few years back. We, as the Office of the Official Receiver, we've been trying to engage different stakeholders, the judiciary, to see how we can have maybe a division in the courts that focuses mostly on insolvency cases, especially in light of the increasing number of cases, to see how we can easily resolve these insolvencies. Perhaps after today, we can find ways of working with ULS, URA, and other stakeholders to see how further we can engage judiciary to be able to allocate maybe a judge or a division somewhere that can be able to handle and help make the work of insolvency practitioners easy, and also help the business community to be able to resolve these insolvency matters that come up on a daily basis. Yes, great.
Thank you. Thank you so much. Yes, Mr. Mugera.
Thanks, Rita. My closing remarks are to the how liquidators, insolvency practitioners should protect themselves. I know that we are speaking to an audience of practitioners. My advice is that not every insolvency case is yours to handle. There are certain companies whose operations are so large, but the resources to conduct the liquidation are so minimal. At the end of the day, liquidation, receivership, administration is very serious business. There is a very high likelihood that you could end up in prison because you tried, you were the funeral service for a company going down. So I know we've been appointed because we are competent, but personally, I know that for complex insolvency matters, I cannot be a valuer. I cannot determine what onerous property is. I cannot determine certain aspects of the liquidation. And before undertaking instructions to be any of the insolvency processes, I would ensure that I would be able to execute my tasks in a manner that covers my back, my tracks. And when I believe I will not be able to, I could perhaps advise a client to try compulsory liquidation by court, in which case maybe the court may make a provision for who meets the costs, maybe the directors or shareholders, but to cover my back, I would not do each one of those things by myself, and I do not have to do all insolvency matters. The second issue is to emphasize what Nelson said in response to Tony's discussion. I still believe that all the sins for insolvency have been placed in the laws, and it would be wrong to look beyond the prescription of those sins as specified within the law. The benefit, I would like to end with the emphasizing for me that insolvency should be a benefit, a clean start for anybody that undertakes the process, and those that have broken the law or the spirit of the law, the act itself has prescribed what the sins are and what the punishment is. Other than that, thank you very much for moderating this panel, which I have enjoyed very much. And thank you very much to the listeners.
Thank you. Tony, do you want to say anything else after?
Yes, thank you, Rita. I just take the point of being proactive, and I think it's actually the solution to maybe change the way URA is being looked at. So I think if we take such initiatives, then there will be no stifle. So we take that point and we thank ULS for organizing this, and this is a point well taken. Thank you.
So thank you so much. I do not see any questions in the webinar chat. Are there any questions in the room? If there are no questions, I would like to request that we are discharged from this position and we hand over back to the Secretariat. We thank you so much for giving us this opportunity. I would like to thank my fellow panelists for the open discussions. Some of them have been on since yesterday, but thank you, each and every one of you. Have a good evening and a nice weekend. Thank you.
I'd like to take this opportunity to thank our moderator, Rita, for this wonderful engagement, for the wonderful, excellent moderation, and a special thank you to our panelists of the day. Thank you for being here and for sharing your insights during this discussion. I'd like to also thank our attendees that have been physically present as well as online from the very start till the end. We appreciate you so much. This is just a kind reminder to fill out the survey or the poll that was shared. We need your feedback on how this symposium went on so that we can improve next year. With that, I'd like to thank you all for being here and have a lovely weekend. This has come to the end of our 2025 Insolvency and Business Rescue Symposium. Thank you all so much. Yes, so we're going to have a group photo with everyone that is present, our speakers, our panelists. We're going to have a group photo. Yeah.